Hearings in the matter of case number CA011-2022 before Chief Justice Zaki Azmi, His Excellency Justice Shamlan Sawalehi, and Justice Robert French. The applicants are represented by DLA Piper. Lead counsel is Mr. Rajesh Pillai, KC, assisted by Mr. Colin Walderick. The respondent is represented by Dittons & Co. Lead counsel is Mr. Rupert Reed, KC, assisted by Mr. James Wheel.
Okay. Before we start, let us decide. We are starting now 3 p.m. my time, Malaysia time, 11 Dubai, and 7 a.m. London. Right?
8 a.m. Your Honor.
You're in London. You're all in London. So court is London. So I'm very sorry. I have to wake you up very early in the morning. Cheryl was suggesting we start at 1 hour earlier. I said, no, give them another hour to sleep. Okay. As usual, I would need to take a short break. Say what? How many hours do you want to speak before you take a break, Mr. Pillai?
Your Honor, I'm in your hands. An hour and a half, perhaps, or 2 hours, whatever works.
Yeah, 2 hours. Shamlan, when do you do your prayers, your afternoon prayer?
I'm fine. Within 2 hours is fine.
So 2 hours. We take first break at 2 hours. 2 hours. That is about 5 p.m.
1 o'clock.
You're 5 p.m. 1 p.m. Dubai, and what that would be 11 a.m.
10 a.m.
10 a.m. London, and then if we continue after 7:30 my time, depending on whether we're going to go on very late today, we need to take a break at another 2.5 hours after 5 p.m. That is 7 p.m. my time. My time 7 p.m. Dubai is 3 p.m. Dubai, and London is 11. Right? No, not 11, 12. No, sorry. If it is 7 p.m., you are 10, 7 p.m., 3 p.m. Dubai, 3 p.m. minus 4 is 11 a.m. Is that right, Mr. Pillai? So we take two breaks. One is 9 a.m. your time. The other one is about 11 something your time. London time. Are you in London?
I think it's 10 a.m. and 12 p.m. for us in London because it's 8 o'clock now. So 2 hours would take us to.
Oh, it's 8 o'clock.
10.
Okay, I thought it was 7 a.m. Okay,
no.
8 o'clock.
So
okay,
10.
Then never mind. We play by ear and see how. I mean, we don't have to strictly keep the timing to strictly, but as long as I have about 15 minutes of break to do my prayers, that's all. That's one. Secondly, a couple of things that we need to clarify from you. How are you going to proceed with your submission today?
Your Honor,
because there is an application for permission to appeal by the respondent.
I understand, Your Honor. I've spoken with Mr. Reed, and what we have agreed, subject to the court, is that I would take up today dealing with my appeal, and I'll have a couple of comments on the cross grounds because they are relevant and feed into what I'm saying. And then, so that would be today. And I don't think I certainly won't be asking the court's indulgence to sit late today. A full day today will be fine for me. Then I understand Mr. Reed will take up tomorrow, and then we would have replies on Wednesday. And of course, by then, no doubt the court will have formulated any thoughts it wants specific answers on insofar as they haven't already been addressed. Does that suit Your Honor?
Yeah, it's okay. It's okay. I, as far as I'm concerned, my time is your time, so it's not an issue. How many hours do you think you would take today? 5 hours? Is it?
I think. I'm sorry to speak over you, Your Honor.
It's okay. It's okay. Go on.
I think I would take about 4 hours today.
Oh, I see. That's not too long. Okay. Before we proceed, I would like to ask Mr. Reed. You have this permission to appeal.
Well, my lord, we're seeking permission to appeal on the cross appeal.
Yes.
That obviously has been, that's a rolled up application. So we essentially make the cross appeal. Your lordships, if the court found that there wasn't, for example, real prospects of success, they would find there was no permission. But it's simply a question of the test that's being applied by the court. As has been intimated by my learned friend, many of the issues on the appeal are mingled with the issues on the cross appeal. So, which is what underlies the agreement of counsel, that essentially the learned friend will have today dealing both with his appeal and with my cross appeal. I will then have tomorrow dealing with both appeal and cross appeal. We will then have replies on the third day on the basis of equal time for each party.
We've had the opportunity to read the parties' submissions in relation to the application for permission to appeal. Speaking for myself, it might be of assistance to the parties if we disposed of that up front.
Yes, we were thinking of we should dispose of your permission to appeal now. We are inclined to grant that your request for permission to appeal.
I will formally make that application, and if your lordships are mindful to grant it, then that will clear away a procedural issue and be very helpful.
Okay, I think that should be okay with Mr. Pillay, I hope.
Well, it would be limited. I think we were thinking in terms of it being limited to your cross appeal on the fourth payment, and not in relation to the costs issue. And with the fourth payment, that would be confined to the argument that the judge should have found fraud on the fourth payment, having regard to the findings he made on the fifth and the sixth payments. Because as I understand it, that really is the compass of your argument. It's an internal inconsistency within the reasoning. And of course, if we granted permission to appeal on that basis, and if you were to succeed on the cross appeal, that would not prevent you from revisiting the costs order at first instance. But that doesn't mean that there's permission to appeal being granted to revisit that costs discretion now.
Do you follow that? Do you follow that, Mr. Reid?
I follow it. I'm just, I think we need some thinking on our side as to whether we would wish to press now our application for permission to appeal. I wonder if I could just briefly take instructions on that.
Okay. Because we want to grant you the permission to appeal on but limited to that points raised by Mr. French, Mr. Justice French.
Yes. Could we go off camera and off for just for 5 minutes?
Turn off your microphone and discuss. You want to take a break, or can you discuss now? Okay.
I'll be back in 5 minutes. I'm not a break.
Okay. Let me discuss now. Yeah. Go on. Yes, Mr. Preet.
My Lord, hopefully I'm back. My Lord, we do wish formally to maintain our application for permission to appeal on the cost issue. We do say that as a matter of procedure, we did not have an opportunity to be heard on the cost issue, and the particular permutation of costs, that's to say, essentially being deprived of 50% of SPM's costs, which in round terms is around $1 million. So we say to be fined to that extent without the in circumstances, factual circumstances that had not been put before the parties, had not been canvassed in court, was procedurally unfair. And we say also that, as you've seen in the skeletons, there was an element of perversity in the decision insofar as, for example, the issues raised were, for example, in respect to the trial bundle, we were largely dealing with Prime, who were heavily represented, the leading counsel, junior counsel. To the extent that they wanted documents in, they had to go in, and therefore for the judge to essentially apply that level of fine, 50% of our costs was unreasonable and perverse. So for those reasons and the reasons set out in our skeleton submissions, we maintain our application, but we don't wish to take Mr. Pillai's time. We realise that this is his day, and for those reasons, we maintain our application.
Yeah, Justice French, how you
Maybe
like
we should hear briefly from Mr. Pillai on the costs question.
I'm grateful, Your Honour. Your Honour, for our part, our concern is that as Your Honour had delineated the scope of permission to appeal in principle, then we'd be happy to go forward. But we were concerned that, as the court will have seen, Malone Friend Skeleton spent some 20 pages talking about what are referred to as additional reasons. And they go so far as to suggest in paragraph 88 of their skeleton that the judge, in fact, should have been bound to conclude that the entire course of events formed part of a single fraudulent scheme, which is, in those circumstances, appears that Malone Friend is seeking to rerun large tracts of the evidence as part of his appeal. That's a different issue. Well,
that's a distinct issue, isn't it?
Well, it is, but we'd say it shouldn't fall within the scope of any appeal. So unless, Your Honour, the court was to rule on that, because it is a different issue, but it isn't one that should come within even the scope of the appeal, we say. Your Honour has the point. We think there's
I don't quite understand. I thought we were inviting you to respond to the question whether permission to appeal should be granted in respect of the costs order made by Justice Glennie.
I'm sorry. On that point, we say no permission should be granted. We dealt with that in the skeleton argument. But I can take, Your Honour, to the transcript.
You say, as I understand it, you say that the respondent was invited to make some submissions in relation to the cost question, and I think that Justice Glennie said something like now or never, or now's the time, or something like that. There was.
Your Honour, there are 3 points. First, it's a discretionary decision that was well within the ambit of what was reasonable. Second, the reasoning reflects the fact that the bank, in fact, lost on most of its claim. So it's entirely natural to see a significant discount in costs in light of the outcome. And third, it is wrong, as Your Honour has picked up, to suggest that the bank didn't have an opportunity to make submissions on costs. And we've cited that in the skeleton argument. That reflected not just the loss, but also conduct. The transcript is cited in our recent skeleton at page 1, paragraphs 114. We can take that up if you want. But yes, in essence, Mr. Reid was asked whether he made his application, and he said, yes, I do. I don't want to paraphrase him, but it's all there on the transcripts. We can go to it now if needed. But
I think what we have heard both of you. We reserve our decision on this issue of cost until after the break. During the break, the judges will have our discussion on how to. But Mr. Reid, you know that cost is discretionary. You know.
No, I appreciate that. But cost decisions can be reviewed whether inconsistent with principle or perverse. So we set out some length in our skeleton why we say it is perverse and why procedurally unfair. Not least insofar as I was pushed to make an application or to make a submission, that was in respect of a proposed decision or make an application in respect of indemnity costs. There's a specific issue on which I was asked to state SBM's position. It wasn't a general application on costs, not least an application in respect of a cost outcome pre-judgment hadn't been canvassed before the court.
Okay, as I said, we reserve that our decision on the issue, this cost, permission to appeal on the cost. We'll discuss, the judges will discuss during the break, and we'll come back with an answer after that.
But in
So
the
as
meantime,
not
you
to-
have permission to appeal on the fourth payment.
Yes.
Limited as
On the
we've
fourth round,
suggested.
your permission, subject to you limiting to your appeal to that reasoning that which you have given. Okay, then, Mr. Pillay, we'll hear you on the appeal proper. Yes, we'll hear you, Mr. Pillay.
I'm grateful, Your Honour. Your Honour, I'm going to begin with a short overview, then look at the judgment, and then go through each of the grounds, and then end with some comments on the cross appeal. I'm going to follow the structure of the skeleton arguments, so it might be useful to have those either to hand or accessible on screen.
بس بغيت أشكرك ما قصرت أنا رشيد الدكتور.
I'm sorry.
I don't know who that is.
Was
Okay.
that? No, it must be somebody outside. Yeah, okay, continue.
So
Continue,
my
Mr.
recent our skeleton argument is at bundle L 1, tab 1, page 1, and then the permission to appeal skeleton is at bundle A, tab 4, page 17. Now, I appreciate the court will have read the material, so I may be able to take points more quickly.
Yeah.
But I make some short points on the structure first. The claim related to an alleged fraud in relation to lending in support of the oil transactions.
Oh, before you proceed,
Yes.
Mr. Pillay, I just realized, if I understand correctly, the loan of the financial facility was granted by the bank to Prime and RENISH.
It was to RENISH, but
To RENISH, okay.
yes, can I?
To
Your Honor,
RENISH.
it might help.
But
if-
I cannot understand for myself, I'm speaking for myself, I cannot understand why this suit for fraud when there is a breach of contract already,
Well, Your Honor,
not for non-payment.
and there's a judgment in favour of the claimant as well.
So
We don't understand.
Are they seeking for two judgments for the same amount?
I think there's
I
a
mean,
slightly different. It's a different amount, but we say it's completely unnecessary, and we've said abusive.
Overlapping amount, isn't it? Isn't it?
So the judgment in each case is against RENISH and MEHTA. In the contract case, it's against RENISH and MEHTA as guarantor. Is that right?
Oh, debtor and guarantor, respectively.
Yeah,
yes.
Right, yeah.
Huh?
And
Yeah.
then the fraud case is brought against, well, both, I suppose, under the law of obligation, so analogous to a tortious claim, but for the same amount.
Yes,
But-
and you'll have seen at the end of the judgment, Justice Glennie was very clear to say, well, look, if you recover something on this contract claim, it's not an aggregation; it needs to be set
Yeah.
against it. And the transcript of that judgment of the hearing, for what it's worth, did raise this with Mr. Reid, and Mr. Reid explained that they thought there would be some sort of enforcement advantage. But on the bottom line is, yes, we don't understand why a fraud claim was ever brought, because there is a judgment against Mr. MEHTA, and we think it's frankly to put pressure on him in a way that the process of this court shouldn't be used for.
I know it's not a point which was raised, but one might have thought that there'd be a notion of extended issue estoppel coming out of the contract claim, that fraud could have been run then. But anyway, that hasn't been an issue. So,
Okay, go ahead. Go on.
My Lord, sorry, just to clarify, it was run then. The case has always been in contract and fraud. And in terms of enforcement in India, you'll have seen that the summary judgment was granted back in 2021. Since then, not a dime of the contractual claim has been paid. We're therefore in an enforcement situation seeking to enforce in India. And if we have a fraud judgment, our understanding from Indian law advice is that enforcement will be easier if we have a judgment in fraud.
so Mr. Reid, was the the contract case also joined in a fraud claim as part of it?
Yes. So summary judgment was granted by Justice Ali back in 2021 on both the contract and the fraud claim.
Oh, then the fraud was set aside, wasn't it?
The summary judgment for fraud was then set aside by Justice Lenny in 2021, which then pitched us into the trial of the fraud claims. But as I say, not a penny has been paid on the contractual claims since 2021.
So you had, I understand, you had a contract judgment, and in the same case where you had a fraud claim, you sought a fraud judgment for enforcement purposes. Okay, I misunderstood. I'm sorry. Yep.
Sorry to interrupt.
No, that's fine.
Okay, thank you very much. Thank you. Yeah, Mr. Pillay, can you proceed, please?
And Your Honour, I wonder if the court could take up Bundle A, tab 4, at page 22, which is the permission to appeal skeleton, which just sets out the structure of the transaction, paragraph 17 to 19.
Yeah, okay.
So there, the funds are provided by the bank and they're paid directly to Prime for the purpose of RENISH purchasing consignments of oil. And there were underlying purchase contracts in relation to the oil. And then separately, there were onward sale contracts with Lanka, a Sri Lankan subsidiary of the Indian Oil Corporation, for sale of oil. And then the oil was shipped thereafter. And then Lanka was to pay money back to SBM so as to discharge the liability under the lending arrangement, so discharge RENISH's liability. And RENISH's margin, looking at 18.5, was selling at a higher price than it had bought from Prime. And large sums of money were frequently transferred between Prime and RENISH. And so that was a structure which is a common structure. Now, the bank's claim that Mr. Reid has just referred to was that the entire arrangement was a fraud. And it persisted at trial in suggesting that there were sham contracts and that there had been a concerted attempt to lull the bank into a false sense of security. And also at trial, you'll have seen from the judgment, the bank sought to run a series of unpleaded arguments that were new, that were not in the particulars of claim. And it also sought to rely on evidence that had not been formally adduced at trial and was therefore not before the court.
Is that a matter which affects the merits of your appeal, one way or the other? The judge commented on that and wouldn't let the bank run an unpleaded case?
It is relevant in the context of the judge's findings and then his assessment as to the inference of dishonesty, Your Honour, but I'm not trying to rehabilitate that.
Yeah, I don't think we should get into the weeds of the wrongdoings of the bank in the conduct of the case.
Oh, I see. Your Honour, we'll look at the judgment, but of course the marker that needs to be put down, and I think it's already been canvassed this morning, is that insofar as Mr. Reid seeks to bring back those points in his additional reasons, then of course that has significant effect on the conduct of this appeal. Now, what I was going to say was that when you look at the judgment, the judge rejected the vast majority of the bank's claims in fraud. But we're here because the judge held that while 4 advances were not fraudulent, the last 2, the 5th and 6th representations, the advances were induced by allegedly false representations, meaning Mr. MEHTA and RENISH were liable to the bank. Now, we say that that conclusion was wrong, and colloquially, there are 4 reasons. The first is that the judge did not have in mind and did not imply the correct principles to finding dishonesty by inference at trial. And the judgment demonstrates that the judge did not have before him the correct legal principles. They're simply not in the judgment. But the judgment also demonstrates that the judge did not have the right principles in mind when reaching his conclusions. This is because none of the relevant considerations are evident in his reasoning. So, Your Honours, this is not a case where the court can fall back on saying, well, the judge plainly had all the points in mind, and it does not matter that they were not fully articulated. Now, had the judge been directed to and applied the correct principles, he should have dismissed the claim in fraud. That's the first ground. Now, the second ground is that we say the judge did not have in mind and did not apply the correct test to determining whether, in fact, there were actionable implied representations. Again, he does not refer to the test, and the relevant authorities were not before the court. But in any event, in his analysis, the judgment does not reveal any of the objective contextual analysis that was required. And in particular, you'll see that the judge was not taken to and did not look at the express contractual terms in this context. Instead, the judge jumped immediately to considering if there was dishonesty. He appears simply to have assumed that the relevant implied representations were made. And again, we say if he had applied the correct test, he would have found there were no actionable representations. Pausing there, Your Honour, the appellants say that the appeal should succeed on either of those grounds. The first instance decision was based on wrong principles of law, and the judgment cannot properly be left as reflecting applicable law in this court. Now, the third ground is that the judge's conclusion was internally inconsistent. And this ground arises out of the judgment itself, because in light of the conclusions the judge had reached on the pleaded case, it was not rational for him to find that the last two requests for drawdowns were fraudulent. In addition, and we will come to this in the judgment, the judge expressly refused to reach any finding as to why Mr. Mehta acted fraudulently in relation to the last two alleged representations, having not done so before at any point, and in circumstances where the judge found there was no overarching trade finance fraud. So in those circumstances, there was no rational basis for inferring dishonesty in light of the judge's other findings. And the fourth head, or fourth ground, is that the judge failed to ensure that the duty of fair presentation was met. Now, there's no mention of that duty in the trial transcript of the judgment. The bank's counsel have not identified a single instance where they attempted to comply. It was one-way traffic at trial. Now, the judge did identify a variety of points against the bank, and that arises in particular in relation to keeping out unpleaded arguments and evidence that had not been formally adduced. But those, we say, are points that would have been obvious to the judge from comparing the pleadings with the skeleton argument and submissions being made at trial. And as is evident from the transcript, the judge and SBM's counsel had discussed the requirement of adducing evidence by hearsay notices. So it was something that he already had in mind procedurally as relevant. But the judge might not be expected to know what other legal arguments should have been brought to his attention. We say, had the duty been observed, then the judge would have had the benefit of hearing legal argument by reference to the proper tests and would have been taken to the relevant evidence that militated against the bank's case. And what in fact happened was that the bank attempted to cherry pick parts of evidence from Prime's witnesses, so the party that had settled, but without bringing those into evidence. And the bank did that without bringing to the judge's attentions the parts of that evidence which supported the appellant's case. So that, by way of overview then, Your Honours, is what we say on this appeal and highlight where the judge went wrong. It's right then now to move to the judgment. And we find that at D16. So bundle D, tab 16.
Can we have the page, please?
It's page, it's 1018 is where the order begins. Yes, it's bookmarked tab 16, page 1018 in bundle D. And then the judgment itself begins the reasons at 1020, 1020.
Okay.
Do you have that?
Yeah. Yeah.
So, Your Honours, I'll first, the judge summarises the claims in the opening paragraphs, and I'll first pick up at the outline chronology at paragraph 6. And you see there that the judge says that the outline facts are not challenged, are not seriously challenged. summarizes the approach and how the bank and RENISH's relationship arose. And then at paragraph 9, he summarizes the requests for payment. There are 6 requests for funds and refers to when they're repayable. And then he deals under that list of drawdowns with the repayments that were made. So 3 were made, and then no other payments were made. And so the bank said there'd been a failure to repay the 4th, 5th, and 6th advances. And of course, that forms the basis for the contract claim. At paragraph 10, we see that in June 2018, the bank contacted Mr. Mehta, heard nothing, and then a default arose under an acceleration notice. And we see at paragraph 11, Mr. Mehta's explanation for what had happened and the context of the trial. And he explains this act of business sabotage, the truth of RENISH issues. And we don't take this lightly, and we note also that this isn't disputed. So this is that the judge has found as part of the facts and context of this case. And Mr. Mehta explains that he had been away on a family event, and there'd been this act of sabotage, alleging essentially that RENISH had been illegally trading and fake accounting. And it was an email that was circulated to bankers in the UAE, and it led to dishonored checks and the closing of bank accounts. And
how much of paragraph 11 is Mr. Mehta's explanation, and where does the judge's finding in relation to that?
Well, the finding I made is at the beginning. That's why I drew your attention to it. The outline facts giving rise to this dispute are not seriously challenged.
So he's saying that Mr. Mehta's explanation is not seriously challenged, in other words.
Well, that's what I take from this, and he doesn't then later say, well, that was wrong or anything like that. I can only go by that, Your Honour, but yeah, that's why okay. I picked that up for you as we went through. Now, Mr. Mehta has explained in various places in his evidence the effect of how this has impacted his ability to get legal representation and access documents. Your Honour, we then see that from paragraph 12 onwards, the judge gives the context of some procedural matters and the worldwide freezing order. And I think it's a matter of record, and the court will be familiar with it, that there was various activity around a freezing order and attempts to serve Mr. Mehta, which were unsuccessful. He says he didn't find out about it for some time. He has now applied to purge contempt proceedings, which were heard this summer. And also, we know that how the trial came about in circumstances where there was an overnight settlement the night before the hearing. Prime came out of the action, and there are all those matters that were dealt with of a set-aside application relating to Mr. Mehta's perceived inability to attend the trial. He said that he didn't feel he could have defended it. There was no adjournment of sufficient time. In his view, he had requested extra time. And so the trial proceeded one-sided, as it were.
Before Mr. Pillay,
yes,
there was a settlement between Prime and the bank.
Yes, Your Honour.
Is there any reason why grounds for settlement?
We have never seen.
No, okay.
We've never seen anything. We've asked about that. The appellants believe there must have been monies paid as well, but we have no idea. All that happened, as Mr. Mehta had explained and was recorded at the set-aside application and is on the transcript. He attended on what he thought was the first day of trial for a trial that the judge himself indicated that had been expected to be led by Prime's counsel team. And he found out that the matter had settled between Prime and the bank. And so Prime withdrew. And then that led to Mr. Mehta seeking an adjournment for 3 months to be able to be put in funds and get a defense lawyers. He had had some legal representation from, I think, an Indian firm, but in the month before trial, he didn't have any representation and he was at trial on his own. But we don't know what happened with the settlement.
Okay.
So I was then moving on to the evidence at trial, and that begins at paragraph 22, page 1028. And there that we see what is said about the bank's evidence. And then the judge at paragraph 24 deals with the factual evidence filed on behalf of Prime and RENISH and Mr. Mehta. And we see at the bottom of that page, the judge records his discussions with the bank about the status of that evidence, because no application was made to put it in as hearsay evidence. And we see that it appeared that at trial there was some confusion, because on one hand it was appeared to be accepted that evidence had not been formally adduced. I'm reading at the bottom of page 1028. But at other times, notwithstanding documents not having been adduced, the bank sought to rely on passages to support inferences against RENISH and Mr. Mehta. And that approach was, the judge said, was illegitimate. We see that about 4 lines up from the bottom of paragraph 24. And what the judge said was, if the statements had not put in as hearsay evidence, they had no evidential value for any purpose. But he then went on to say this: that is not to say that they are wholly irrelevant. They might directly or indirectly raise questions about the claimant's case, so that's the bank's case, or identify weaknesses in it which ought to be addressed, but they're not evidence. So the point there is that this material may have contained points against the bank's case which were potentially relevant. And in the next paragraph, paragraph 25, the judge deals with the expert evidence, and effectively he treats it similarly. We see at the foot of paragraph 25, although Prime's expert, Mr. Drew, was not called by Prime, nor was his report sought to be relied on as hearsay evidence, it had no evidential status, but was relevant to the extent of providing context to the bank's expert. Now, it's a point I'll come back to in due course. Moving on then to the law, paragraph 26 sets out that this is a claim in deceit under Article 31 of the Law of Obligations, and that's not in dispute. And it also it's not in dispute that the test for deceit reflects that in English law. And paragraph 27 is where the judge set out the test that he applied on implied representations. Paragraph 28 deals with a point that is not an issue. And then 29 deals with the judge's approach to the standard of proof and also the principles relevant to a finding of dishonesty by inference. Now, I've said that we say the wrong test was considered in each instance. So we'll come back to that on the grounds. And paragraph 30 is a case where the judge dealt with the correct test for pleading. And he identifies there that there was a clear disparity between the case pleaded and the one sought to be made on submissions. He also noted that primary facts had to be pleaded so the defendant knows the case against him. And that, of course, has to be done before trial, so that the defendant then has an opportunity to answer it. And we see there that the judge notes that if the bank wanted to advance a case which was not reflected in their pleadings, then they needed to amend. Now, the claim then is analysed from paragraph 31 onwards. And paragraph 32 sets out the two distinct parts of that claim. Recall that there was a claim under a facility agreement, and it was said that there was a facility agreement representation. And also it was said that there were payment representations. And judgment 32, paragraph 32, sets out, by reference to the pleading, where the implication, the implied representations are said to arise. We see there at 32.2, at the foot of page 1032, Your Honours, it said that by the payment representations, there were these following implied representations. And you see those, so it said that the implication included that there'd been a concluded sale agreement onwards, that there was going to be advance payments, there was going to be shipping of an oil consignment, and that Lanka would pay RENISH. Now that's all described as a purported sale. And then you see the judge goes on at paragraph 33 to identify how he says this is false, how the claimant bank says it's false. And specifically, it said that the purported sale was a sham transaction. And the judge has underlined and its component transaction. So that's all of the bits from A to E in that paragraph above were said to be a sham. And that's what the bank's case was. And it said that Mr. Mehta and RENISH and Prime never intended to perform any of the sales terms or the contracts, that each sale was a device to deceive the bank. And it's saying that the facility agreement, the guarantee, were never intended to be complied with. And that it was intended...
If there was no sale, what happened to the oil?
Well...
there are a lot of questions.
There would be a lot. There are a lot of questions, but Your Honour, what we're going to come to is that actually this is the case that was pleaded, and the judge found that most of it didn't stand. Because what I wanted to say is, pausing there, as you say, if you look at the claim that's put here, the claim alleges that the entire relationship was a fraud. From entry into the facility agreement to the underlying sales, it's all described as a sham. And that claim, Your Honour, was not sustainable. I'm going to make 5 points based on what the judge in fact says.
Was transferred from from the main was it Indian company to Prime, to RENISH, and to the final purchaser, the oil itself. Was it actually transferred from the original seller to whom what's his name, the bank paid the first amount? The bank picked the first. Yeah.
Your Honour, I mean, I'm not sure that there's evidence that that happened on every occasion. I mean, RENISH's position is that, as far as it understood the position, Prime should have carried out that delivery so that Lanka would pay.
Yes.
And our understanding is that what went wrong was that Prime didn't deliver for the last two. But that was on Prime, as it were. It's not something that Mr. Mehta and RENISH say they are liable for. But if I get back to what's said about the fraud, you've seen that it's suggested that this whole arrangement was fraudulent. And I want to make 5 points. And the first, if we look at paragraph 34, the first point is this, and then I'll take you to the paragraph. The case in that this was all a sham collapsed at the very outset. And you see what the judge said at paragraph 34. You see, so he's introducing the point. He said the allegation at paragraph 40 is that the purported sale and component transactions was a sham. I emphasize the words and its component transactions. On any fair reading of that allegation, it amounts to a positive case that each element of the purported sale was a sham. And then it points out, the judgment points out, that the bank had, in a letter, effectively said that the contracts were genuine. And the judge says halfway down, well, this is an important concession and one which ought to have been made by an amendment. And then he'd asked the bank about all of this, and the explanation he was given, he says, was entirely unsatisfactory. And he said an allegation of dishonesty is not likely to be tossed around, should never have been made unless there's a proper basis for it. There was no proper basis for that allegation here. So we start at paragraph 34 with the judge saying the sham goes, and it effectively seems to have gone by concession, but they didn't formally do it. And that's crucial because that is a central plank of the case that was no longer available to support any inference of fraud.
Now, sorry, but this is the Lanka transactions where the admission was made way before trial, and indeed months before.
I'm sorry, I'm sure that Mr. Reid will make his submissions in due course. I'm just looking at the judgment and recording what is said here, Your Honours, and the judge said Your Honour, the judge said that is a concession and it should have been amended. Now, there are further then points. The judge summarises further arguments that were made by the bank at paragraph 35. And then at 36, you see that he points out three distinct lines of evidence that the bank sought to develop. Now, these are the points that Your Honour, His Honour Justice French raised with me earlier. It's important that I just take you through them, simply just to point out that these are arguments that the judge has said were not pleaded and form no part of the bank's case. And they form no part of the bank's case on this appeal either. So, Your Honour, the first, paragraph 37, is that there was an attempt to argue that Renish and Prime operated as a single entity. And we see that, summarise that in the first line. That's the first overarching point, that they operated in effect as a single entity throughout the material time. And the conclusion at the end of that paragraph is there is not even a hint of this in the bank's pleading, so it was not part of their case. Your Honours, the next point is at paragraph 38. It's described as focusing on an action by Renish and Prime in opening bank accounts in the name of Prime with NBK as an Emirati bank, Kuwaiti bank, on the 16th of February. And we look at and halfway through, there is a suggestion about inferences about their joint behaviour in this regard. And the judge says in the final sentence, the allegation now sought to be made with its emphasis on the timing of the opening of the accounts goes well beyond what is pleaded. So that again was not pleaded and isn't part of this case. Then the third point relates to the genuineness, and I'm reading at the top of paragraph 39, Your Honours, to the genuineness or otherwise of documents presented by Renish to the bank when requesting the 6 payments. And it was even alleged that there was some sort of forgery. And the judge says about 4 lines up at the foot of that paragraph, there is no allegation of forgery in the particulars that came, nor is there any reference in the pleadings to the alleged mismatch between payments and specific cargoes of oil. In other words, there is no pleading of any of the primary facts from which the inference of fraud in this respect is sought to be drawn. So again, these points are not part of the case. And in paragraph 40,
sorry, just before we go on, the
yes, Your Honour.
Reference in paragraph 38 to Mr. Sada's evidence.
Yes.
I see that it appears that what the trial judge is doing there is referring to the bank's case, referencing Mr. Sada's second witness statement, but the judge goes on to say that that's not actually in evidence. Is that correct?
Yes, it had not been adduced in evidence. And if you recall, Your Honour, we looked at paragraph 24, where the judge described the discussion that had been had with the bank about the status of evidence that hadn't been adduced by hearsay notice.
And there was no hearsay notice. I understand that. Yep.
Yes. And what he said was, well, it's relevant if it goes against the bank's case. But this was an example of the bank seeking to rely on it to make it a positive case of fraud. And the judge said, well, no, it's not pleaded, and you're relying on evidence that's not before me and that you didn't adduce.
Thank you.
I'm grateful, Your Honour. Now, paragraph 40 is the point about pleadings, and it's trite law, but it's worth refreshing the point here, is that the point about requiring this in a pleading is because the defendants, as the judge says in the second sentence, are entitled to fair notice of primary facts intended to be proved and the inferences to be drawn. And it's not sufficient that part of the case be canvassed in expert reports, and that, in fact, a party is entitled to proceed on a case that's put in pleadings. And he went on to say that actually, if Mr. Mehta had attended, he would have been able to object to these lines of evidence and would have succeeded, so they'd have been excluded. And the final sentence is the vice. It's a general vice that applies, of course, in relation to unpleaded cases, is that were the court to allow these lines of evidence to be deployed against them, it would be at risk of making findings of fraud on the basis of a case which the defendants have had no notice of.
There are some court rules which expressly require particulars of fraud to include a statement of the facts upon which the allegation is made. I haven't been able to find any equivalent to that in the DIFC court rules, but I think there's a common law position about that, isn't there, in some of the English authorities? In Australia, we have it in the court rules.
Your Honour, yes. I mean, in England, you've probably got it in the Commercial Court Guide as well. I'm not conscious of it being in the DIFC rules, but the common law requirements are that they need to be distinctly pleaded and distinctly proved. But I'll come to one of those authorities in the context of the submissions on ground one, because there is a distinction between the test for pleading and then, the test that is applied in relation to assaying that evidence at trial. But so if we pause there, what we have here already is that the sham argument, the argument this is all a big fraud from the outset with no genuine underlying transactions and so on, picking up what Your Honour, the Chief Justice had asked about, that went at the beginning, and so did these additional lines that were not pleaded. And then we look at...
in that respect, Mr. Pillay, in that respect,
yes,
the judge did say expressly to say, I shall exclude these matters from consideration.
Yes, so he excluded those. Yes, he does. So he excluded the unpleaded points and then was focusing on what was pleaded. And I'm going to now go to what he said about the pleaded case. And the first aspect of that was what's called the facility agreement representations fraud. And you see there's a subheading there above paragraph 42. And he says at the beginning that he accepts that there was a representation made in relation to the facility agreements. He doesn't cite any test there. But the reason that doesn't affect us on this appeal is that, as we'll see, he rejected the claim on these representations. So it's of no moment. But what he then says is he, first of all, having found that there were representations at para 42 at the end, he says he's seen nothing to persuade him that in the period of negotiations, the representations were untrue. Okay? And then at paragraph 43, he describes the transactions that went under the contract. So this, I think, goes slightly to the questions that Your Honour, Judge Zaki was asking about, because he describes at the top of page 1039 how the facility was used by RENISH for numerous high-value transactions in the oil and petroleum trade with various third parties, and add to these the first 3 transactions with Prime, which were also repaid in full, save for an insignificant shortfall. And that amounts to 10 successful transactions carried out with the use of the facility. Judge says, I have no reason to doubt that these were not all bona fide transactions. And he understood that, with the exception of the Prime transactions, Mr. Reid had agreed. And so it's important to see that there is a wider trade that RENISH carries out here. And it's not just one transaction with Prime involving this Lanka oil. it's one facility agreement with SBM, yes, but there is a wider trading business here. And it's one that prior to this action was unblemished. So what the judge then says, again, in this rather long paragraph, is that he's not, he does not accept the argument that was put that this was a subtle and carefully crafted fraud. Because you'll see that the bank suggested that actually all of this was done because it's a really careful fraud to try and build up the bank's confidence and then default. He says he prefers a simpler explanation, Your Honours, that it was this facility agreement was negotiated as a means of providing finance for genuine oil transactions. And then he says things may have gone wrong later, but he says that he sees nothing to persuade him that the facility, on the balance of probabilities, that the facility agreement's representations are false. So he rejects that fraud claim. He says that there's simply no evidence to support it. And he says he's considered the bank's case on this. And I'm looking at paragraph 44, and at the bottom of that page, just above the internal page number 22, he says, one cannot help but be struck by the number and value of legitimate deals carried out with the aid of finance provided by the bank under the facility. It is entirely speculative to suggest it was all done to lull the bank into a false sense of security, to encourage it to make advances to the limit of what was covered by the facility before defaulting and walking away from it, leaving the bank to suffer loss. And so that's where the judge has rejected the first fraudulent representation claim, because he says it's a legitimate arrangement. And we put that together with the context that all the underlying contracts were genuine, as was conceded. So he says he does not find this proved. Look at 47. And that, I don't know, it's an odd formulation. Perhaps it's taken from a Scottish approach, but ultimately, the net summary on paragraph 47 is that the claimant said that there was a facility agreement representations fraud, and the judge rejected that. So therefore, there's no grey area there. He rejected the claim. And then he moved on to the payment representation fraud. And this is the fifth area. And you see that at paragraph 48, he refers to the argument on the representations. I'm going to come back to this, but this is where he deals with them. He says that they are the representations referred to and concerns only the 4th, 5th, and 6th payments made to Prime. And he says that he refers to the allegation was that the bank was induced to make these payments by express or implied representations, and he refers to the pleading at paragraphs 12 to 13. Then he summarizes that it's accepted that the Lunker contracts were genuine. And then he also says that the position was somewhat at odds with the bank's pleading in paragraph 5. So there is a tension in the bank's own presentation of the representations identified by the judge, because the bank said it has, paragraph 5 of its reply, because the bank says it has no positive case and makes no admissions as to the nature of and extent of any trading relationship. So he introduces the representations there. And he reaches a conclusion at paragraph 50 that he thinks that there is evidence which is admissible and compelling that monies received from the bank by Prime pursuant to requests by RENISH were within a matter of days dissipated by Prime to RENISH or other entities involved with RENISH for no obvious legitimate commercial reason. So he finds that that is compelling. And then at 51, he says that these payments were made and that Mr. Mehta's offered no explanation. Now, he refers to the defense there, but he goes on to say, well, and the defence is that these were strictly transfers in the ordinary course of business. And I'll unpack that a little later, but the summary of that is that RENISH and Prime had a long-standing relationship, which Mr. Mehta had given evidence of, and that payments from Prime to RENISH went backwards and forwards. And these were in the ordinary course of business, and there was no further explanation given by Mr. Mehta. And what the judge said was, had there been a proper explanation, I don't know why, I can't think of no reason why Mr. Mehta would not have said what it was. So absent an explanation, I accept the inference, so far as it relates to the 5th and 6th advances, these payments out to RENISH and PetroHub are, as the bank had put it, characteristic of illegitimate and fraudulent trading. The timing speaks for itself. So pause there. He says that because payments were made out of Prime shortly after each of the 5th and 6th advances, and he didn't have more of an explanation from Mr. Mehta, he finds that that is basis for inferring fraud. Now, if you look at paragraph 52, the judge explains that he doesn't make any other findings about issues relating to Prime. At 53, he makes no findings about Prime's involvement in the fraud. 54, he again says he focuses on the pleading, looking at the final paragraph, rather than looking at all the evidence in the round. But at 55, he emphasizes the limits of his finding. He says the inference I draw relates only to the 5th and 6th advances. And he says there's no similar link in terms of timing to justify a similar inference in respect of earlier payments. So, pausing there, he's restricting this on all of this evidence to just finding these 2 representations were fraudulent, and he finds that on the basis of the timing of payments out of Prime. And in fact, it's only paragraphs 50 and 51 that reflect the judge's evidential case on this. And it's right to note, sorry, at paragraph 54, the judge makes this general comment in the middle of it. He says that there are other points summarized at paragraph 35 above. And he says, although they involve inference to be drawn from subsequent conduct, they can be treated as casting light on the conduct. But he then doesn't rely on any other particulars from that paragraph. He doesn't say, and I rely on A, B, C, and D from that paragraph in support of the inference. It's an entirely general reference back. And then, as he says, I do not accept the argument the court can simply look at all the material and conclude that fraud in some ill-defined way has been established. So that is how he has concluded there was a fraud in this case. It's those 2 paragraphs. And then he says this at the end of 55. He says, it is idle and impermissible in the absence of evidence to speculate on what may have occurred to alter Mr. Mehta's intentions in his dealings with the bank. But I find the bank's case is established in respect of these last 2 advances. Now, Your Honours, we say that this sentence reflects an astonishing failure to consider the impact of the conclusions he had drawn, and I'm going to come back to it. But he's acknowledging here that for there to be a fraud in relation to the last 2 payments, there was a change of intention. There must have been a change of intention, but not just any change. This is a very serious change, an intention to commit a fraud. But the judge says also that there's no evidence as to what had occurred. And he even goes as far as to say that on the material before him, that would require speculation. So actually what he's done there is not identify any evidence here to support this basis for an alleged change of mind. And we say that he's given here no consideration as to the inherent improbabilities as to why it was unlikely that Mr. Mehta and RENISH, who are well established in the Emirates, would choose to commit such a fraud. And it's particularly striking given that the judge has rejected the idea of an overall trade finance fraud. He's rejected the idea of an overall sham. And we say that the finding is also particularly unlikely, given that Renish and Mr. Mehta would have direct personal liability in contract anyway. This is not a situation where there's a getaway plan. And we also say that the judge has actually ignored the explanation given by Mr. Mehta, and which is corroborated by evidence which should have been brought to his attention.
What did Mr. Mehta say in his witness evidence?
So he said that it was in the he said it was in the ordinary course of business.
Normal business transaction.
Yeah.
But did they explain what they were for, what they paid
We'll
for?
try and find a reference, but I think that the judge is right to have it. He hasn't given any more detail about these specific transactions. But I will return to that after the break, if I may, Your Honour.
Yeah.
Now, I'm going to move then to ground one, Your Honours. Having looked at the judgment, we've seen that the claim was brought under Article 31. And if I could ask you to, if you've still got that judgment up, to scroll then back up to page 1030, paragraph 29.
Okay. Yes.
Now, so that opens with the judge saying the standard of proof required to make good an allegation of fraud is the ordinary civil standard, i.e. the balance of probabilities. Now, there's no dispute that that's the standard of proof. Now, this is a case of inference from primary facts, and the question the judge was dealing with required specific considerations to be taken into account and to be given weight, as he himself noted. But what he stated there in the second, well, probably no, just the second sentence on the next page, 1031 at the top, all that is required is that the primary facts give rise to an inference of fraud or dishonesty, which is more probable than any innocent explanation. Now, the judge there has failed to take into account four key relevant principles to the exercise before him. And I'll deal with them in no particular order of prominence, but the first is from the CMOC case. Now, can I ask you if you've got the bundle I, which is the legal authorities, Your Honours? I'd like to go to bundle I, tab 32, or if you'd like page numbers, let me know.
Give me the page number, please. Page number, please.
Your Honour, this is page 5009.
5009. Okay, thank you.
Or the judgment, the title page is a 5008, but if you let me know.
Yeah. Okay.
Now, that was a case in the commercial court where, in fact, the defendants were unknown. So the trial was carried out like here, with just the claimant and the judge. It involved a fraud carried out on a Chinese business through hacking, which led to the siphoning out of many millions of dollars and euro from its bank accounts. The case was based on inference, and like the present one, as I've said, no defendants attended. What we are concerned with is at paragraph 13 in that judgment, for present purposes. Where the judge was looking at the test in relation to inferences, and he says it follows, particularly in this case, but often in case of fraud, that much of CMOC's case depends on the drawing of inferences. And it's important to note that an inference of fraud or dishonesty should only be drawn where it's the only reasonable inference to be drawn. And they refers to a decision of Mr. Justice Tier. And so the corollary of that point is that if there is an alternative innocent explanation that can reasonably be identified, then the court cannot find fraud. Now, that's well-established law. We've cited cases in which it's been cited, it's not been overturned. Most recently, I've cited in the footnote in our skeleton argument at para 44, the recent skeleton argument, the Antonov, Snoras and Antonov case. There's some criticism from the bank about reliance on this CMOC authority, but it goes nowhere. It's not outdated or wrong in law. But in any event, the logic underpinning this statement I've taken you to is reflected in other decisions. So I take you now, if I may, to the decision of Mr. Justice Calver in ED&F Man, which is at tab 34. The paragraphs I'm going to take you to, page reference of the bundles is 5191. Do you have that there? And I'm going to look at paragraph 70, dealing with the burden of proof concerning allegations of fraud. And there, Mr. Justice Calver said that cogent, where fraud is alleged, cogent evidence is required. And then he cites, who was then Mr. Justice Lewison in the Food Code case, that says, although the standard of proof is the same in every civil case, where fraud is alleged, cogent evidence is needed to prove it, because the evidence must overcome the inherent improbability that people act dishonestly rather than carelessly. On the other hand, inherent improbabilities must be assessed in the light of the actual circumstances of the case. Now, pausing there, and I know that His Honour Justice French has given us a Court of Appeal authority, which we can come to in due course. I don't think there's much in debate, really, about these authorities, in the sense that the burden of proof is on the claimant, the standard of proof is a civil one, and then it's a question of what are the sort of things you have to take into account as a judge when you are assaying the question of dishonesty.
Well, the Court of Appeal judgment I see is cited in paragraph 70. Bank of St.
Yes.
Petersburg.
Yes, exactly. There you go. So the cogency of the evidence must be commensurate with the seriousness of the allegation. And I don't think that particularly changes what's said. And then what's important in the next paragraph, 71, which is, again, on the same line as CMOC, is that the judge bears in mind as to inferring fraud or dishonest conduct generally. It's not open to the court to infer dishonesty from facts which are consistent with honesty or negligence. So you've got to have the fact which tilts the balance to justify the inference of dishonesty. It's not open to you to find dishonesty if the facts are consistent with honesty or negligence. So it could be careless, it could be incompetence. That's not a fraud. Then he refers to the requirement for a claim of proving fraud is that the primary facts proved give rise to an inference of dishonesty which is more probable than one of innocence or negligence. And that's from the Keckman case. And it's quite useful to look at that Keckman case, perhaps. I'll pick up on it shortly. But there is a distinction there between the requirement of pleading the facts and then how you test them at trial. And that's what Mr. Justice Calver goes on to explain here. Because if you look at little 3 in paragraph 71, so, Your Honour, that's 5192 of the bundle now. Although not strictly a requirement for such a claim, motive is described as a vital ingredient of any rational assessment of dishonesty. And that's from a decision of Mr. Justice Briggs, of course, now in the Supreme Court, because as Mr. Justice Calver points out, by and large, dishonest people are dishonest for a reason. While establishing a motive for conspiracy is not a legal requirement, the less likely the motive, the less likely the intention to conspire unlawfully. And then at point 4, assessing a party's motive to participate in a fraud also requires taking into account the disincentives. This includes a disinclination to behave immorally or dishonestly, but also the damage to reputation, both for individual and, where applicable, the business, and the potential risk to the liberty of the individuals involved. So again, these are all points that go to the assessment, the textual analysis of whether a dishonesty, an inference of dishonesty is appropriate. And the judge had none of these before him. And the third point I make is by reference to the Court of Appeal decision in Jafari Fini. We look at That's at tab 45, page 5558 of the bundle. And this is obviously the Court of Appeal discussion where he starts at 558, halfway through, deals with the standard of proof. And if you look at paragraph 40, again, the civil standard is the balance of probabilities. That is, again, not in dispute. We see there what Lord Justice Richards says, which is cited at paragraph 40, which goes over the page, about the flexibility of the standard, enabling proper account to be taken of the seriousness of the allegations to be proved and the consequences of proving them. This all goes to what are you taking into account? And then the judge, Lord Justice Carnwath, I think, says, thus in civil proceedings, the presumption of innocence is not so much a legal rule as a common sense guide to the assessment of evidence. It is relevant not only where the cause of action requires proof of dishonesty, but wherever the court is faced with a choice between two rival explanations of any particular incident, one innocent and one the other not. Unless it is dealing with known fraudsters, the court should start from a strong presumption that the innocent explanation is more likely to be correct. And you're dealing here with people who were blameless until these allegations. And to a similar vein, and this is the last principle that I wanted to take the court to, is the decision in first instance in autonomy last year, which is the large allegations of fraud in relation to the HP transaction, at page 4136 of the bundle. You see a paragraph 473, Your Honours. This is Mr. Justice Hildyard.
Sorry, what's the tab number?
The page number 413, tab number is 27, Your Honour.
Thank you.
The tab 27, then paragraph 473 in there, bundle number 4136. And I look at paragraph 473, which cites again the key authorities in this context, including Jafari Fini, including the Fiona Trust and Privilov decision of Mr. Justice Andrew Smith, Your Honour, which is cited in the Bank of St. Petersburg case, paragraph 42. The judge here says that cogent evidence is required to justify finding of fraud or discreditable conduct, and the courts recognise it's generally unlikely that people engage in such conduct. That's why where a claimant seeks to prove a case of dishonesty, its inherent improbability means that even on the civil burden of proof, so we're not shifting the burden of proof, we're not diluting it, but the evidence must be strong enough to overcome the general presumption that innocent incompetence is more frequent and more likely than dishonest design and fraud. The more serious the allegation, the more cogent the evidence required to overcome the unlikelihood of what is alleged and thus to prove it. The more serious the consequences for the individual involved, the less likely he would be to run the risk of these consequences. Then we go on to a citation of the cases, and then the Jafari Fini Court of Appeal citation that I've just taken you to. So can I just pause there to take stock, because that sets out the principles to be considered when you are analysing the evidence. Specifically requires cogent evidence to find fraud on the civil standard, specifically requires consideration of the presumption of innocence and the inherent improbabilities. And this is the guidance the court should be applying when deciding whether the evidence before it justifies an inference of dishonesty. And if a court does not apply those principles, then it is taking the wrong approach in law to determining whether or not evidence justifies a finding that dishonesty should be inferred.
Well, no prejudice to the argument about cogent evidence, but the question of the probability of somebody doing something is very much fact specific, isn't it? I mean, in the Bank of St. Petersburg, everybody was lying, demonstrating that such conduct was not improbable.
Well, of course it depends on the facts, and I'm going to. That's why the second way in which I approach this ground is to say, well, let's look at those facts here.
Yes.
But Your Honour, it doesn't take away from the fact that you have to consider the inherent improbabilities, and you need to consider that presumption of innocence, and you need to consider, well, what are these people's motives here?
I think the presumption of innocence is an unfortunate turn of phrase. It's really borrowed from the criminal law and also international civil and political rights, I think, in the context of criminal law, which it's another way of saying that the prosecution has the burden of proving guilt in the criminal case. I mean, I understand what you're saying, that in other words, one looks at inherent improbability if, unless there's some contrary sort of factual context, as in St. Petersburg, but elevating it to a presumption of innocence is maybe putting it a bit high.
No, Your
With
Honour,
all due respect to whoever said that.
Yes, well, Your Honour, I think that it's not my phrase, it's a judicial phrase that I've just taken you to. But I agree. But perhaps if you still have that on screen, that I think how it's softened in terms of phrasing, but not softened in terms of impact, is perhaps by Mr. Justice Hildyard. And what we've seen here, it's the general presumption that innocent incompetence is more frequent and more likely than dishonest design and fraud. And none of what, with respect, I don't think, none of what Your Honour, Justice French has just said takes away from the importance of the points that Mr. Justice Calver identified about motive, which again feeds into disincentive and so on. So what you need is a fully analysed consideration of the evidence on which is relied. Now, can I take you back?
Your case is that there's no overarching conspiracy, and the facility representation has been found. That there's no finding of a facility representation, so it starts to look like a sort of an out of the blue opportunistic sort of event, if there were to be some explanation for it.
Sorry.
Actually, I would like Mr. Pillay to now take the facts.
Yes.
The facts as the judge found, and apply to the law. And what's your conclusion?
If I may, I just want to take you to the test again as the judge, and then we can do that if we may, and that probably take us to the break. So if we go back to the judgment, paragraph 29, which is a 1031 in the bundle, tab 16 in bundle D. Okay, and we saw that the judge said what the standard of proof was, and then at the second sentence on the next page, page 1031, all that is required is that the facts must give rise to an inference of fraud, which is more probable than an innocent explanation. What we say there is that at best is an incomplete and therefore incorrect approach, because without more, that's a phrase that favors the party alleging fraud without taking into account any of the points that I have just mentioned. And in particular, the judge did not take into account in his test the need to consider inherent improbabilities. The judge did not take into account the need to consider, and I use this phrase perhaps for the last time, but the general presumption of innocence, because that's the way that it's put in the case. However you soften it, the force, I think, is understood. And relatedly, it meant the judge did not take into account the relevance of motive and disincentives, including as to reputation and personal liberty. And it does not require that dishonesty or fraud be the only explanation. So we say the law is contrary to principle. I just want to, before I just go to the facts very quickly, deal with what the bank says, because the bank relies on cases called Sofa and Keckman, and both those decisions actually deal with strikeout arguments, where it's alleged that the pleadings are not sufficiently particularized. So they're not dealing with the position at trial, And perhaps I could just make that good by looking at one case, the Keckman case, which is at I-48, so 5884 in the bundle, in the legal authorities bundle, tab 48. And I think here this makes the point that His Honour Justice French was raising about what needs to go into the pleading. The claimant does not have to plead primary facts which are only consistent with dishonesty. The correct test is whether or not, on the basis of the primary facts, an inference of dishonesty is more likely than one of innocence or negligence. So that's at the pleading stage. And there he cited Lord Millett from Three Rivers, saying there must be some fact which tilts the balance and justifies an inference of dishonesty. So pausing there, if your pleading doesn't include a fact that tilts the balance in favour of dishonesty, then you'll be struck out. And so that's why Mr. Justice Flo, as he then was, said at the interlocutory stage, when the court is considering whether the plea of fraud is a proper one or whether to strike it out, the court is not concerned with whether the evidence at trial will or will not establish fraud, but only with whether facts are pleaded which would justify the plea of fraud. So that's why there's a difference between looking at the test for a plea, the pleading test, as opposed to the assaying at trial. And the judge has identified that distinction in that sentence, as he said the court is not concerned with whether the evidence at trial will or will not establish fraud. And then he says it, cements it in the next sentence. If the plea is justified, then the case must go forward to trial, and assessment of whether the evidence justifies the inference is a matter for the trial judge. So that's what we're talking about here, is whether the evidence justifies the inference and how the judge should have approached that question. And if the other side, if the bank is right in saying, well, these cases are all that's relevant, then you've got the wealth of authority to which I've just taken you to, which is inexplicable, and it's plainly not right. Sofer and Keckman deal with the pleading test. The cases I've taken you to deal with what the judge should have in mind when he's assaying the question. Now, why I say that there's no evidence that the judge considered any of these principles is a starting point that His Honour, Your Honour Justice French identified, which is you say the judge had rejected A, B, and C. And yes, I showed you how the court first clarified that the arguments with Lanka were not a sham. So the argument that the overall setup was a sham failed and had been conceded. The contractual agreements were genuine, one. Then the judge rejected attempts to rely on unpleaded points. They just don't come in. The judge rejected the suggestion the facility agreement was fraudulent. He rejected the idea that the facility agreement and genuine transactions were part of the scheme to lull the bank into a false sense of security. He, in fact, said he was struck by the number of high-value legitimate transactions. And he rejected the argument that the first four requests and advances could have been the subject of fraudulent misrepresentations. So in doing that, he had dismantled pretty much all of the fraud claim that was set out in the pleading. So then if we go back to paragraph 50, which is at 1041. You see, he's talking about the basis for finding dishonesty, and he says he's relying on these payments out of prime. And the judge also then says that he effectively wanted more explanation in writing from Mr. Mehta. But he doesn't anywhere here consider, the context in which he's already made all of these other decisions. He does not consider how his rejection of the other aspects of the fraud claim made his findings on these two payments inherently improbable, particularly when there was no facility agreement fraud, no lulling into a false sense of security, and no shortfall on the first three advances. So he didn't apply any of these aspects, and there's nothing here to show that he's taken them into account. And second, the judge had wrongly rejected that innocent explanation. And we say that was unprincipled for two reasons. The first is there's a credible explanation on the face of it. And that's because there were payments from Prime to RENISH after the other innocent advances as well. So it's not as though there were suddenly payments just from Prime to RENISH, suddenly after the 5th and 6th. There had been payments before. I dealt with this in the permission to appeal skeleton, or Mr. Mulderick did, I'm sorry. Bundle A, tab 4. And this is the page 38 of the bundle. If you see paragraph 50, beginning the sole factual finding. And you see that what the judge's concern, and including in his later judgment on permission to appeal, was the timing. But as we explained, the cogency of that evidence is doubtful when the timing of payments in respect to the other advances is considered. And I don't need to take you through, I'm not going to read it all out, but you see in relation to the second advance, there were payments straight out. A few days later, no finding of fraud was made in relation to the second advance. You look at the fourth advance in little b there. Payments 6 days later, 3 days and 7 days later. No finding of fraud in relation to the fourth advance. But in relation to little c and little d, yes, there were payments out, and there was fraud found. But that doesn't distinguish from those previous examples. So we say the judge was wrong to conclude that the transfers after the 5th and 6th advances were remarkable because similar had previously happened and had not been a basis for finding any allegations of fraud. And
your argument and the respondent's argument like mirror images of each other, aren't they?
Well, I think
he says, given what's found on the 5th and the 6th, you must have found
you should
fraud
go
on the
backwards.
4th. You say, given what's found on the 4th, you can't have found fraud on the 5th and the 6th.
You're right. All I would say is that one of our mirrors is cracked, but other than that, you're right. I mean, I don't shy away from there are aspects of goose and gander arguments here. We say that actually, this is the right approach is to look at it from have they built up their case, and the judge had to say, well, look, this has gone, this has gone, this has gone, this has gone. What are the inherent probabilities now in relation to this? What are the motives? It's just not here, Your Honour. We've got 2.5 paragraphs, even allowing for cross-references back and so on. There's nothing there of the sort of analysis that was required. And Your Honour, there is the further point, which is that there was corroboration from Prime's own position, and I deal with this in the skeleton, the same document. If you scroll down to paragraph 50.4, because Prime's pleaded case was confirmed that there was this relationship. If you have bundle D2, so bundle D, then go to tab 2, please. So the same bundle that we had the judgment in. You see the defense of Prime. I'm so sorry. I'm just going to get you the page. It's 65, I think. 625. I'm so sorry.
625.
Yeah, so that's Prime's defense. Well, if you start at 620, please.
Okay.
Now, obviously, this pleading is sworn in the usual way and is on the record. You see at paragraph 1.2, Prime's case is that Prime and RENISH were at all times commercial counterparties that imported, exported and traded petroleum between various territories. And it says that between 2014 and 2018, RENISH made purchases that amounted to approximately 30% of Prime's annual turnover. So pausing there, this is a significant relationship. And if RENISH is purchasing, then Prime will be paying. And then 626, I think, paragraph 15, unpacks that a little bit. Paragraph 13, sorry, at 624, points out that Prime and RENISH developed an extensive commercial relationship in which they cooperated to purchase and sell oil and related products. And then in relation to payments, you see paragraph 14 at page 625. Is a reference to payments that would be made.
Sorry, what use do you make of Prime's pleading in the appeal?
So the point I make here is that this is evidence that was in the bundle.
It's a pleading.
Sorry, this is a sworn pleading. So It's sworn, so therefore comes with a statement of truth. And it is a point that corroborates the position as to the existence of an ongoing commercial relationship justifying payments as between these two parties on an ongoing basis, which is in line with that ordinary course of business that Mr. Mehta had described. And further, if I need to, I will say that this point, this evidence, and alongside evidence from Mr. Sada and Mr. Drew, which corroborated the fact that there were regular and large payments between the two, is material that was relevant because even if it hadn't been adduced, because Prime wasn't in the case and it hadn't been adduced formally by the bank, that evidence went against the bank's case and therefore was relevant on the judge's own reckoning. Because I took you to paragraph 24 and 25, where the judge said if there is material that might undermine or demonstrate weaknesses in the claimant's case, then it would be relevant. So that's why I say this is all material that was relevant to the judge's assessment. And it goes to the innocent explanation.
Is it customary
point.
I'm sorry for interrupting you. Is it customary to rely upon statements of truth in support of pleadings as evidence in hearings? I mean, I know that ordinarily one has a certification, usually it's by the solicitor in our jurisdictions to say that this is in accordance with my instructions or something along those lines, have reasonable cause. But you've got a statement of belief that the facts stated in the defence are true. Now, that may be facts which he knows directly. They may be facts of which he's been told by somebody else, but he has a state of belief about them. It's a little bit of a stretch to invoke that as evidence, isn't it?
Your Honour, I don't accept that it's a stretch, because the reason why you invoke the discipline of swearing it is so that it's sworn. People are not taking it lightly. What I accept is that you would want evidence at trial in support of it. And what I say is that, as we've said in the skeleton argument to which I've taken you, there was evidence in support of it from Mr. Sada and Mr. Drew, which supports the existence of a long-standing commercial relationship where payments were being made by Prime to RENISH for genuine commercial reasons. And where I see the force of what you might say is, well, look, I'll take that on board as admissible evidence, but how much weight should I really give it? And I think that may really be where the point goes. I accept that that would have less weight than a witness statement that is sworn.
Well, we've got Mr. Sada's evidence, which,
yes.
His statement, which wasn't in evidence, which says those things, but that's not in evidence. And yet we're going to use a pleading.
Well, Your Honour, I say that you should be taking that into account. And I don't know if you want me to take you to that evidence or not.
Well, I understand your position. I was just putting out my concern about it.
Yeah, well, I understand that. And you know, these are the restrictions that happen because the material wasn't adduced. And so therefore, but what I say is it's legitimate for me to pay that in aid, Your Honour, but it's not legitimate for the bank to pay that in aid, because the bank could have adduced it. And what the bank otherwise should have done was bring material in that evidence that undermined its own case to the attention of the judge. That's what the judge said. We can go back to paragraph 24 if you want. But he plainly had this. Yeah, that's the point, is that it works one way, as it were, because the judge said, well, if there's something in there that goes in favor of Mr. Mehta and against the bank's case, I should know about it. And where it goes for me is, well, look, here, Mr. Sada's evidence confirms this, and I put that into the skeleton arguments. Mr. Drew's evidence confirms it. We put that into the skeleton arguments. So we don't need to go, those points all confirm it. Those then give you the innocent explanation corroborating what Mr. Mehta said. And so that's why that should have gone into the judge's assessment, and it didn't. And then I go on, and I've already, I think, made this point, but I go on to say that the judge then didn't consider the innocent explanations and the general presumption that would apply, given here that RENISH and MEHTA had an unblemished commercial history. They're not known fraudsters, to use the language of the Court of Appeal and Jafari Finney. The judge didn't raise that. And the minimum, we say, is acknowledgement of these points and then a rejection on reasons, if there is one. But that's not what you see. There's nothing. And the judge did not consider what motive there might be. And again, that is directly relevant given the number of legitimate transactions the judge himself has identified as arising from this facility agreement, so on this facility agreement alone. And it was directly relevant given the judge found the first 4 requests and advances were not fraudulent. There's no reason, simply no reason, why Mr. Mehta or RENISH would have committed a fraud like this. And the downsides of Mr. Mehta's life and business were plain. This was a motiveless fraud where negative consequences were predictable, those consequences being a complete loss of reputation, risk to liberty, exactly what the judge should have had in mind. And this would have, we say, had to have been a particularly unsophisticated and essentially pointless type of fraud. And look, I just want to, I think, finish shortly on this point by looking at paragraph 55 again, the end of paragraph 55 in the judgment, if we may. And I have made this already, so I won't dwell on it for too long. But it's that final sentence. It's the point there that drives home how far removed the judge's reasoning was from the principles to which I've taken you. He says there must have been a change of intention. So that means a change from innocent to dishonest. But he says there's no evidence of it. And so he's not going to speculate. But if he was entitled to infer fraud, Your Honours, then that's exactly what he should have been doing. That's exactly the exercise he had to carry out. He simply failed to do it, and he didn't realise. And this is the point, because he didn't have the law to hand. He didn't realise the error he was making. He found no evidence about a motive to commit fraud. He found nothing to rebut any of the general principles against innocent incompetence and so on. And he therefore could not properly infer dishonesty and should never have reached that conclusion. Your Honours, my final point is about is a narrow point on reversing the burden of proof, because that, we say, comes out of paragraph 51, which is and the language which I've already taken to you, where he said, well, had there been a proper explanation, I can think of no reason why Mr. Mehta would not have said what it was. And then he said, absent any explanation from Mr. Mehta, I accept the bank's case on inference. That's a reversal, Your Honour, of the burden of proof. And no adverse inference could properly have been drawn in these circumstances, particularly when there was that corroborating material to which I've taken you. Now, we dealt with that in the recent skeleton. Can I just ask you to look at one extract from authority, which is in bundle I, page 7754, which is an extract from the grant and it's down as grant and mummery, and I know that Mr. Mumford will be very unhappy at that. It's grant and Mumford. The page is tab number 79, and it's page 7754. And that's just a summary of the position on Wisniewski. And I know my learned friend cites the post office case. I think if Phoebe doesn't really take this much further. If you look, the part I'm interested in is at 7754, paragraph number 34066. So that says a claimant can only derive support for its case by inviting the court to draw adverse inference from a failure to call evidence if the claimant itself has raised a case to answer by its own evidence. The relevant witness can be expected to have given relevant, if not necessarily determinative evidence, and so on. Now, as Mr. Mehta has explained in his evidence, he cannot access RENISH documents, and he's necessarily been hampered in the preparation for trial as a result. He's given what evidence he can. I can take you to that if that's necessary, but I don't think it's in dispute. We say for these reasons, the judge erred in law because he has effectively drawn an adverse inference or reversed the burden of proof when he wasn't entitled to. He did not have the right principles in mind on ground one, and in fact failed to answer the fundamental question because he couldn't why Mr. Mehta suddenly turned to fraud after running legitimate transactions. The evidence disclosed no motive, there's no finding, there's no consideration of the inherent improbabilities. So we say the conclusion of fraud is unsustainable as a result, and the appeal should be granted on ground one alone. Can I leave that there for ground one? I don't know, Your Honours, if you want to take, if that's an appropriate moment to take a break before I move on to ground two, or pick up any final questions you might have on this before I move on.
Yeah, I think that's a good time to break now. So how long shall we break? Judges? How long will you require? 20 minutes? Half an hour? I don't know.
15 minutes for me, but
15, 20 minutes, 15, 20 minutes. Let's start again, say, yeah. Say in, let's say 20 minutes for people to get the drink, pour out the drink and things like that. 20 minutes.
I'm grateful. So is that 5 past the hour, whichever
yes,
hour that
5 past the hour.
I'm grateful.
I'm going to keep the link on. I'll just turn off the camera and turn off the sound, mute the sound, but the link will continue to be here. Okay, thank you. Okay, we're ready. Yeah, Shamlan is here. On the cost, permission to appeal on the cost, we've decided that you put your submission on permission to appeal, and then as if you're putting in the full appeal itself, and then we will decide so that we give an opportunity to Mr. Pide to reply, and then we decide at the end of the day. Okay, thank you.
You'll be pleased to know this is a process borrowed from the High Court of Australia on special leave applications.
That was the idea of Mr. Robert French, which we all agree. Thank you very much. So, Mr. Pillay, yeah. you can hear the we are having a thunderstorm here now. So you hear bombing sign. It's not the bomb. It's just a thunderstorm going on outside here in Malaysia. Not in London. You don't have to look at the back, Mr. Reid. Okay.
I'm
yes,
grateful,
Mr.
Your Honour.
Okay,
I think we're expecting thunder here later today as well, but perhaps we'll outrun it. Now, I was going to move on to ground two, and we deal with this in the recent skeleton from paragraph 65 onwards for your note. And it may be useful to have to hand the permission to appeal skeleton as well. It's paragraph 52 onwards for that. The essence of the complaint here is similar to that which the the appellants raised in relation to ground one. The judge applied the wrong legal principles and overlooked the test. In order to succeed on a claim under Article 31, the bank first has to establish that there was an implied representation. Now, that's because the existence of a representation is one of the elements of a cause of action. I think we can see that just from the judgment. So if you have that at D16, you look at paragraph 26 and move to page 1030 in the bundle, Your Honours. And you see deceit there, Article 31, liable in deceit if he makes a statement that is fraudulent, he intends that a person should rely on the fraudulent statement. So I think what we'll first do, if we may, is look at how the judge approached this. And he did that at paragraph 27, directly below, at page 1030. He summarizes the law as saying, he says, of course, its right to representation need not be expressed. And then he says, it can be implied from all the circumstances. He then refers to Corinth Pipeworks, and we'll look at that shortly, and a suggestion that in finance fraud there is a commonly and implied fraudulent representation. Then he says that may well be so, but all depends on the particular facts and circumstances. So that really is the high watermark of the judge's analysis, that phrase. And there are 2 points to make. Firstly is that Corinth doesn't support that analysis, doesn't actually say anything about it. And secondly, that we don't find that sentence reflected in any authority. So if we look at the Corinth Pipeworks case, that's at bundle I, tab 10. And I will get the page shortly. 3710, Your Honour. So if we see there, that's a decision, hearing was 25th November 2014, and counsel, if you look at the bottom of 3010, you see there was only counsel for Barclays, Mr. Taylor. No representation for the defendant. Now the reference that was relied on, the paragraph is 84 to 86 in that decision, which begins at 3728. Now, at the beginning of paragraph 84, there's a reference to a claim under Article 36. And then 4 lines down, that there's a claim as to liability under Article 31 for deceitful misrepresentations. And then the judge simply records the first dishonest misrepresentation they made was the payment representation. And you can see that that's effectively what the claimant seems to have tried to ape in this case. And essentially, the claimant's approach is saying, in Corinth, the court found there was a payment representation, and they try to then elevate that to be some general principle of there are always these representations in a banking arrangement. And of course, that's nonsense. As we'll see,
if I ask somebody for a loan and they advance me a loan and I have no intention of repaying it at the time that is advanced to me, that would be fraud, wouldn't it? Because I'd be misrepresenting this. There'd be an implied representation as the state of my mind.
Well, I think there'd be an express representation when they're in the contract. That's the point.
Well, there may be that as well, yeah.
Well, I don't know that there necessarily might be that as well, Your Honour. I think that's a crucial point. If there's an express representation, I will pay you. Clause 4 will say, I will pay you back in these increments. That is a contractual obligation, 1. It's also an express representation that I will pay you back. Yeah. And if I make that express representation, but intending never to fulfill it, then that is a deceit claim based on an express representation.
All right. Well, let's suppose you don't have it in the contract. I'm just trying to think of another example, because there are plenty of examples of situations. We have something called misleading or deceptive conduct, which is a statutory cause of action in Australia, and that usually involves express or implied representations, and it can be representation by conduct. For example, if I give you some advice and I'm an expert, there's an implied representation that that I know what I'm talking about or have the relevant expertise. Or if I promise to do something, there's an implied representation that I have the capacity to do it and the present intention to do it.
Yes.
And the question is how far you can generalize from that. I know it's fact specific, but it's not unusual to find implied representations in promissory statements which go beyond the promise itself. Because very often a promise is not a misrepresentation as to present fact. It is a promise, I will do something in the future. And if I don't do it, it doesn't mean that I was fraudulent at the time I made the promise. Circumstances may have intervened. But if I make the promise, and at the time that I make the promise, I fully intend not to perform it, or I know that I don't have the capacity to perform it, there's an implied misleading statement there, isn't there?
I'd say that it would depend on the facts. I don't think you can generalize across contexts. And I think that it would be very surprising if DIFC or indeed English law accepted that there is always an implied representation in the context of any lending agreement in circumstances where these things are, particularly at this level, highly papered and you have a series of express representations. Where it also
goes not a question of law so much as a question of fact, isn't it, in this case?
It will be, but there'll be this, which is that it's also a question of whether the representation, even if one is made, is actionable. Because what are you going to actually, so what's it reasonable for the representee to rely on in the circumstances? And I'm going to come to that because it requires a bit of unpacking by reference to the legal
reliance
test.
Is the causal connection to loss.
Well, reliance actually is relevant in the first stage as to whether it was reasonable, whether there was an actionable representation, because not every statement of opinion or representation of fact gives rise to a potentially actionable right. Does it?
If you don't rely on it, there's no causal connection to your claim loss.
Sure, it follows at that stage as well. But I think part of my point is that if you don't consider whether a representation made is actionable or not, then you've got the test wrong anyway. You haven't applied the law correctly. Perhaps we can come back to this, Your Honour, because we're looking at it not just in hypotheticals, but there is some fairly solid grounding to all of this, which I think wasn't before the court. So, Your Honour, we're looking at the Corinth case, and it was put on the basis that, well, there is a general type of fraud here. Actually, the Corinth case just found that in that case, there were deceitful misrepresentations. The judge, I think Mr. Justice Cook, says 5 lines down that the first dishonest misrepresentation was the payment representation. So in that case, that's what he found. There isn't actually, in this case, never mind the paragraphs that are cited, but there isn't in this case any analysis of the test or any actual submission as to the law relating to Article 31. It's just the law is cited at paragraph 84. And then the judge says there was a dishonest misrepresentation called the payment representation. And further down, he says there was a second dishonest misrepresentation.
But the first two lines, the first two sentences at 27, you would accept it is trite that a representation need not be express.
Sorry, what are we talking about? Are we back in our judgment?
Yeah, back at 27.
Yes, of course.
And you accept also it can be implied from all the circumstances.
It can be implied from all the circumstances, yes, but that's not really anywhere near what the test actually is. I mean, it is a subset or sub part of it. It's highly general, and if that was all you were going on, then you got the law wrong, and you wouldn't apply it properly. Can I just make that good? And the reason I say that is that it's also trite law that the test is much more complicated than that, because it's very well established in the English authorities. If we look, the sort of touchstone over the last 18 years has been the IFE and Goldman Sachs case. which is at tab 90 in the legal authorities, page 8485. That was a case involving misrepresentations arising out of information memorandum provided by Goldman Sachs. And at first instance, it went up on appeal, but it doesn't affect this point. At first instance, Mr. Justice Toulson, paragraph 50, is page 8485, summarised the test, which has then stood the test of time. See it at page 8405 there. In determining whether there's been an express representation and to what effect the court has to consider what a reasonable person would have understood from the words used in the context. Second sentence, in determining what, if any, implied representation has been made, the court has to perform a similar task, except that it has to consider what a reasonable person would have inferred was being implicitly represented by the representor's words and conduct.
Well, that just tells you it's an objective test.
I'm sorry, sir.
That just tells you it is an objective test.
Well, it goes a little bit further. It requires you to consider what a reasonable person would have inferred was being implicitly represented.
The reasonable person is a person that the judge's imaginary friend.
I'm sorry, I didn't hear that last bit.
It's the judge's imaginary friend, the reasonable person.
Yes.
By whom the judge applies an objective test rather than what people might have had in their heads at the time when they heard.
Quite. The subjectivity is not where it comes down. And then if we then look at the Marmay decision, which is at tab 54, at paragraph 115, which is page 6097. And I think the points that I need to make are basically set out here. So firstly, if we look at the footer page 1097, do you have the subheading implication applicable principle? Sorry, 6097, yeah.
Yes, I still have a small white semicircle rotating tantalizingly, but it might be that if you read the relevant passage, it'll...
Well, so he starts by saying there's no dispute as to the legal principles applicable, and he quotes that paragraph we've just seen. And then he summarizes various cases in which that passage has been applied. Now, I say that because I want to cement the fact that this is very well established law. And then paragraph 116 goes on to make this important point, so that because it amplifies what Your Honour has just said about the objective test, because it says whether any and if so what representations were made must be judged objectively according to the impact that whatever is said may be expected to have on a reasonable representee in the position and with the known characteristics of the actual representee, right? So that is objective, but here you're looking at what would the bank have thought. Then there's a further
I think that accords also with the law in Australia in relation to whether representing conduct is characterised as misleading or deceptive. One can have regard to the where it's not a statement to the public but to a particular individual. One can have regard to the context in which that individual would understand what was being represented.
Yes, and I suppose sophistication is the key point that we make here. And then at paragraph 117, a bit further down the page, there is reference to the point made by citing Mr. Justice Hamlin, as he then was, saying that in a deceit case, it is also necessary that the representor should understand that he is making the implied representation and that it had the misleading sense alleged. A person cannot make a fraudulent statement unless he is aware that he is making that statement. To establish liability in deceit, it is necessary to show that the representor intended his statement to be understood by the representee in the sense in which it was false.
Well, that's a requirement of Article 31.
It is, and it's one that needs to be specifically met in any analysis. And also, if you just move on to paragraph 120, which begins at 6099 at the foot of the page, a submission from Mr. Quest, Queen's Counsel, which the judge just accepted at the following page, that the court will not or is very unlikely to imply representation from conduct in terms which are vague, uncertain, imprecise, or elastic. Now, that then sets out some flesh on the court's approach. And I then ask you, Your Honours, to look at the JP Morgan and Springwell case at I-47. So that's tab 47, but page 5854. This is another very long judgment, and I think sometimes we suffer from it all being electronic. We've got all the unnecessary bits, but I apologise for that. We start at, this is a case, Your Honours, where representations were said to be made in the context of investments over a period of time into Russian bonds in the nature of treasury bills. Misrepresentation was one of the elements. If you look at paragraph 668, the second half of that paragraph, the decision of Mrs. Justice Gloucester, she then was. And she starts, first of all, by saying in the paragraph, some of the statements which are impugned were indeed statements of fact. And she goes on to talk about those. And then in the final penultimate sentence begins, it is also relevant to consider whether the relevant provisions demonstrate that in the context in which the representations were made, it was reasonable for the representee to rely on the statements that were being made rather than upon his own judgment. In other words, were they actionable at all? And then she went on to say that in my judgment, as in IFE and Goldman Sachs, the question of what actionable representations, if any, were made has to be considered by reference to the relevant provisions in the, and she sets out the various contractual contexts.
The only question we are concerned with here on this ground is whether it was appropriate for the judge to identify an implied representation. All of the rest is found in Article 31. We don't have to go to the cases for that, do we? It's the statutory elements of deceit are set out in Article 31. I know it reflects the English law anyway, but it's the word. It's the text of the statute, isn't it?
Well, it's. I mean, firstly, it's accepted in this court that the English law.
The English law. It's the same rule in England as in any other common law jurisdiction.
Yes.
If you're dealing with a statute, you go to the text of the statute. Now, everything you've been telling us from the cases is in the statute, apart from the question of implication, which is really, I thought, the core of this ground.
Well, it is, because the point is that if you are implying it, then you need to look at the objective characteristics of what was done. So it's as you say, the judge's friend, the man on the Clapham omnibus, as it used to be, and then you will take their characteristics into account. You will also consider, well, in those circumstances, was it reasonable for that person to conclude that a representation was being made to them?
I understand all of that. The only point I was making is that some of the passages you were taking us to were really dealing with the elements of deceit, which we find in Article 31. That's all.
Well, I see. Well, I mean, I don't need to rely on the elements of deceit, but what I do is raise them so that you can see, Your Honours, how you assess the receipt of an implied representation. I'm not going beyond the fact that you need to set out in this court what the law is on implied representations, because it's not set out in the Corinth case. And all of these principles are relevant, and none of them are set out in this case either. Because if you look at the phrase that the judge relied on, it can be implied from all the circumstances. That doesn't cut it. I make no bones about it. And that doesn't come from Corinth, because that phrase isn't used in Corinth. So the judge doesn't actually identify, Your Honour, where he's got his phrase from. And again, at best, it's a partial summary. Now, I move on. Sorry, Your Honour. The other point that I wanted to make was that out of that last case, is the implied representations and context does require things like looking at the contractual suite of documents. And that's what I'm going to do here. Can we look at the contract here is at H29. And you're not going to find any of this in the bundle. Sorry, you'll find it in the bundle. You won't find any of this in the judgment.
So what's the tab number?
It is, forgive me, 29 is the tab number, Your Honour.
Thank you.
Page.
And it is page 3. If we begin at 2993, just so that you can see the front page.
Okay.
And so, do you have that? That's the facility agreement.
I'm still waiting.
I'm sorry.
It's all right. It's not your fault. It's the electronics.
I don't know, Your Honour, Justice French, if you have the PTA skeleton at A4, that's the shorthand of the points I'm going to make. So tab bundle A, tab 4, page 44.
Thank you. That's tab 4.
And then page 44 in that.
Yep, thank you. Yes, I have that, thanks.
Okay, well, so what I'm going to do, and I don't know if H has turned up yet, but I'm going to take, we're just going to look at those clauses so that we've got them. I think it's worth doing. And so from the H bundle, perhaps, Your Honour, if it's possible to take a note of these, and then you can pick up on it. But page 3004 in the bundle just is the definition of repeating restrictions, repeating representations. And that says that it means each of the representations set out in clauses 15.1 to 15.6, 15.9, 15.10, 15.11, and then 15.12 to 15.27. Then the facility is referred to at paragraph 2. Purpose is referred to at paragraph 2.5. That's at page 3008. We note in passing that there's not been any allegation that purpose was not complied with. Then the terms in relation to utilisation requests and so on are set out at 4 onwards. And then at page 3027 are the various representations. And there are listed 27 representations. And I think we counted 24 of those are repeating representations. And the important ones for our purpose is at 15.9 is that there's a representation that there is no event of default. Look at 15.9 little 1. No event of default is continuing or might reasonably be expected to result from the making of any utilisation. And 15.10 says that there's no misleading information, and that refers to no misleading information in material that's been provided by the borrower. 15.26 at page 3031 says the repeating representations are deemed to be made by reference to the facts and circumstances then existing on the date of each utilisation request. So all of these representations that are repeating representations, 24 of them, are repeated so this was repeated at the request for the fifth advance and for the 6th advance. And just to make good the point about, we saw that there's a representation that there's no event of default or possible event of default. We look at clause 17 which is at page 3038. We see that clause 17 is saying there's no 17.1 has the events of default, and B includes misrepresentations made in any of these documents. So there is a repeating representation that there is no event of default, which includes that there is no misrepresentation in the documents you have. The documents obviously include the promise to repay. And it goes wider, because given that the bank's claim was that there was an entire sham, well, the documents on the face of it would include lots of misrepresentations within this definition, but they're all covered. And the point is, we'll come to it with the test, because we say the judge did not have in mind the correct test from the cases I've taken you, and he did not consider whether any actionable representations have been made in the first place. And if we can look back at the judgment, which is at D16. But the judge deals with this at paragraph 50, but before we come to it, and we've looked, it starts dealing with paragraph 48, which is at page 1041. You see the subheading is on 1041 tab D16. We say that in order to consider whether there had been any actionable representations, the judge had to firstly say to himself, I've decided there's no facility agreement fraud. There's no scheme to lull the bank into a false sense of security. There's no fraud on the contracts with Lanka. The first four requests were not dishonest or fraudulent. That's part of all the circumstances test. But he then had to look at the contract and say, right, well, here is the contract. The contract at each of these provides that at each time a request was made, 24 representations were repeated to the bank. And that included saying that there was no misrepresentation in relation to any of the documents and so on. And in doing that, the court also had to be saying, well, and this representation, this alleged implied misrep, is being made to the bank, which is a sophisticated, well-advised party in Mauritius, which also has the benefit of these representations. So the court has to say, well, in those circumstances, would the bank reasonably have understood that there was going to be an implied representation which covers the same ground as these express representations and the express obligation to pay? And we say, no, the bank would have known the only representations that were being made to it was this suite of express representations, because that covers the pitch.
Can I just identify,
yes.
Sorry, Mr. Pillay, can I just identify the findings which the judge made of the factual circumstances of the relevant payments? I've got paragraph 9. Between January and June, RENISH made 6 requests for funds to be transferred by the bank to Prime pursuant to the facility agreement, accompanied in each case by what was said to be contracts between RENISH and Prime for the purchase of oil to be sold on to Lanka, and by pro forma invoices said to have been presented by Prime under those. So that's a finding of fact which covers the 5th and the 6th payments, right?
Yes, that's it.
Okay. And is that it?
Yes. And then we go on to 48.
Right, okay.
And 48, Your Honours, starts with the judge summarising what representations are being alleged there.
Sorry, Mr. Pillay.
Yes.
I know you went a long way, but I couldn't quite. You were talking about 22 representations having been made in the agreement. Are you saying that because they were made there cannot be implied misrepresentation? Is that what you said?
I'm saying, essentially, Your Honor, I'm saying that the court has to consider whether there are implied representations by reference to the contracts and the other circumstances. So the circumstances are there's no fraud in all of this, in the other transactions. And in these contracts, every time a request is made for utilization, there are express representations being made by these contracts. That's the force of the contracts. That's what the bank has the benefit of, is that there are representations being made to it. And so I'm saying that in those circumstances, given you are the bank, sophisticated, you no doubt have these on your standard terms, because that's what you've got in your express representations, the bank could not have believed that there were also implied representations being made.
I see. Okay.
There is nothing actionable being made on top because it's already covered. It has a contract and it has all of these express representations. And that's the exercise that was carried out by Mrs. Justice Gloucester in Springwell, when she looks at the contracts and looks at what's done and says, well, can there be implied representations? Can the bank really have thought that there were implied representations being made? And sorry, the other point that the court would have to find is that did Mr. Mehta consider and know that he had personally made an implied false representation just by making a utilization request? Is that realistic in circumstances where that's just a function of the contractual arrangement? And so it had happened 4 times before.
There was only one agreement here involved, isn't it? There's one agreement, but a lot of drawdowns and repayment and drawdowns and repayment until the final 2. Okay.
But the court had to think on the 5th and 6th ones, it still had to run this exercise for each of, in the context of what had all happened and what representations had been given through the contract. And there's no consideration of any of this in the judgment. I'm going to make this good.
But assuming for the 5th and 6th drawdown, the facts had changed, and the Mr. Mehta or RENISH kept on drawing down, although the circumstances had changed.
Well, there would need to be consideration of all of that and factual findings to support that assumption, Your Honor. There isn't anything like that in this judgment.
Okay, good. Thank you.
What you're describing, Your Honor, is a case that isn't factually proven on the judgment in front of you. And Your Honor, we say that the test was flawed, because all he said was you consider all of the circumstances. But even on his case, even on the judge's test, he didn't consider all of them. So that's why I say if we look at 48, he begins there by identifying the representations that are allegedly made. And you see that he refers back to the pleading. He refers to the third, I'm looking 4 lines down, the allegation concerns 3rd, 4th, 5th, and 6th payments. Summarizes it. It's that the bank was induced to make these payments. And he refers back to paragraphs 12 and 13 in the particulars of claim. And then he says, well, and that claim is somewhat at odds. I'm looking at 2 sentences, the final sentence. This is somewhat at odds with the bank's pleading in its reply. Because in the reply, they had pleaded something about there being no positive case about a relationship. Okay. And then at paragraph 49, so that's all the judge is doing there is identifying representations that form the claim. Then at 49, he refers to how he's excluded evidence. And we've talked about that. And then at para 50, what he does is say there is evidence which is admissible and compelling. And then he goes on to describe the fact which he relied on to find dishonesty. We've already looked at that. So he's talking there about monies received by Prime and dissipated for no obvious legitimate commercial reason. And he uses the pejorative word dissipation. And then he's finding at para 51, he goes on to say he finds that the payments were made, and we've seen that. But what he's done there, Your Honours, is simply jump to considering whether there was an inference of dishonesty. He's jumped the key threshold test, and you don't find in the judgment anywhere any of the analysis required to find whether there are actionable representations. There's no mention of the Fuller test, I've said that. There's no mention of the contractual terms. There's no consideration of the express representations being repeated in the contractual terms. There's no objective analysis of what the reasonable representee in the bank's position would have thought. There is no mention of Mr. Mehta's knowledge or intention here about intent to make a representation or making that statement.
Just going back to paragraph 9 for a moment, Mr. Pillay, back to paragraph 9.
Yes.
Was there an express, just might be buried there somewhere, but was there an express finding in relation to the 5th and 6th payments that a contract was presented which was not in fact a contract between RENISH and Prime, and that pro forma invoices were presented which were not in fact true invoices?
Was there a fact found?
Yeah, by the primary judge.
Not that I have found. Malena Jr. will.
I mean, if somebody obviously it'd be fraud if you said, I have a contract when you didn't, and you presented a piece of paper which purported to be a contract. I have an invoice which purported to be an invoice but wasn't. There'd be a pretty clear-cut case of fraud there.
Well, that's not the case.
There's no express fact finding to that effect.
No. There's a utilization request. Yeah. That's it. So the rep, and that's how it's pleaded, Your Honour. And if we go back to what I was saying at 50, the judge had described the pleading, so described what was being argued, and then he jumped straight to saying, I'm finding evidences to dishonesty. That's why I say he hasn't considered the context to the alleged representation, and he hasn't considered, as I say, the contract terms, the express representations made in those contracts. He hasn't considered what the reasonable representee in the bank's position would have thought. Is there an implied rep here as well? There's no mention of Mr. Mehta. There has to be a finding that Mr. Mehta intended that there was a false statement being made implicitly. He hasn't even thought about that. What is there to show what Mr. Mehta thought? And then that's why I say when you look at paragraph 51, the judge has gone on to talk about the reason why he thinks these payments don't have an explanation. And just, Your Honour, Justice French, to pick up on your point, we do know, I took you to it in the ancient history earlier this morning in your afternoon, that the judge rejected the allegation that there were no genuine contracts with Lanka. That sham argument was rejected. So that was actually conceded. So that can't be a basis for a fraud claim anyway. It's also been rejected cases based on forgeries because they were unpleaded. So the sort of points Your Honour was, I think, hypothetically putting forward, at least there are findings here which run counter to that. I think that's about as high as I can put it. If we find other findings, no doubt Mr. Reid will find them, all right, and I can reply. But this is my understanding.
The simplest case against you for the bank would be simply that you put together a couple of fake contracts, dollied out a couple of fake invoices, and gave them to the bank and got some money via.
Well, that's not. But that's not the case. That's not the pleaded case. The pleaded case is, as you've seen, there was a massive fraud.
I'm really looking at how His Honour reasoned. He seems to be going to the payments.
Well, this is it. His Honour Justice Glennie went straight to the payments without thinking about the representation. He's not made a finding here, Your Honour, about whether the representations test is met. He hasn't considered any of the things that I have referred you to, which the authorities are clear on. and therefore by 51 he's accepted the bank's case that there were dishonest misrepresentations, but he hasn't actually made the findings required for the first 2 or 3 limbs of Article 31. And then at 52 and 53, if you look on, you don't find the answers there. That Justice Glennie said that he was making no findings about other companies, no findings about Prime. And then at 55, as we've seen, he went back to his finding about fraud, because he says the inferences only relate to the 5th and 6th advances. And then he effectively gives his answer. So what you have there is that the judge is not at any stage considering the threshold questions to whether there's an actionable representation. And Your Honour, we say that the Corinth case doesn't assist any of this because that case turned on its own facts. But as I showed you, Justice Cook there just said, this is the first dishonest representation, this is the second dishonest representation. Those are highly fact specific. But there's no such thing as a trade finance fraud or commonly implied representations. And bluntly speaking, if the judge had somehow assumed that there was such a thing, and there's a hint of this in the permission to appeal judgment, well, we say that's fundamentally contrary to principle. Every question as to whether implied representations exist turns on the facts of a given case. Even the examples that Your Honour Justice French was giving to me in context about advice cases and so on and so forth, which are obviously a different context, but you don't always have, there is always this implied representation. There might be one, it would all depend on the facts. And we say that where all of this leads then, Your Honours, is that under ground 2, the judge did not have in mind the correct test, and he did not apply it. He did not apply it to finding whether there were actionable representations. And the judgment was therefore wrong as a matter of law, and the appeal must succeed on ground 2 alone.
Thank you.
So unless I see Justice French, you're wryly smiling at me, does that mean I should go on, or are you about to bowl me a googly?
What do you want me to say? Appeal it loud.
Perhaps with some reasons in due course, Your Honour. No,
That's all right, Mr. Pillay.
If everyone's happy for me to move on, then I shall.
Yes, please.
See, I am.
Yeah.
Your Honour,
Yes.
then ground 3, and look, I deal with this in that recent skeleton in paragraph 78 onwards, section C4. I don't need to make a meal out of this because we've covered the ground quite a lot. The starting points, though, let me just orient the court by reference to some law, is that I-75-7620. This is the Volpe and Volpe case. It's a recent Court of Appeal decision dealing with appeals. It is 7620, Your Honour.
76.
Sorry, can you give us the tab number?
Yes, Your Honour, it's tab 75.
Thank you.
Volpe.
Now, Volpe and Volpe, and all I need is the head note, but if I can just orient us this way. This ground 3 applies even if grounds 1 and 2 fail. So this court were to hold that the judge below applied the correct test on law. We say that that finding should be overturned. And it's well established that an appellate court should rarely overturn first instance decisions due to errors of fact. And we have well in mind that if the conclusions a lower court has drawn were broadly speaking reasonable, then the fact another tribunal might reasonably reach a different conclusion does not necessarily warrant a successful appeal. But let's look at the head note in Volpe and Volpe, and that reflects paragraph 2, which is Lord Justice Lewison decision. I'm just taking it from the head note because the key point is that an appeal per court, I'm looking at little 5, can set aside a judgment on the basis the judge failed to give the evidence a balanced consideration only if the judge's conclusion was rationally insupportable. Now, Your Honours, where we come to here is that in light of the judge's other correct findings, the judge's ultimate conclusion was rationally insupportable, and it does not require this court to rehear evidence which should have been adduced at trial. This is not, Your Honours, some sort of island hopping ground of appeal, as you sometimes hear criticised. We haven't chosen select parts of a judgment here and there to try and manufacture an appeal. We've just travelled directly down, and as I've endeavoured to show you, directly down the path of the judge's analysis, and then identified where he was irrationally diverted. So, if I can give you just 5 points. The first, you have this already, but the judge should have considered the context to the decision that there had been an actionable misrepresentation in relation to the 5th and 6th requests, in the context of his earlier conclusions that every other element of the financing arrangement was non-fraudulent. And there's a nuance to be raised here. The bank suggests that the judge was equivocal in relation to the 4th advance, and we say that the point can be dealt with shortly. The bank had alleged that the 4th advance was the subject of a fraudulent representation. The judge made no finding of fraud in relation to that allegation, so he rejected the bank's case on the balance of probabilities. There's no grey area here. Now, in relation to this, and you've had the paragraph references we've gone through, but I'll just speak them into the note. The judge had either rejected or made no findings at all in respect of each of the elements of paragraph 12 of the particulars of claim, which set out the payment representation. So he'd found, or cemented by the concession, that there were valid contracts with Lanka Oil and that there was no overall fraudulent scheme. That's judgment paragraph 34. He'd found that there were valid contractual arrangements that were legitimately operated between Prime and RENISH under the facility agreement with those other third parties. That's judgment 42 to 44. He found that there was no positive case regarding the alleged relationship between Prime and RENISH, judgment 48. The judge had already excluded evidence about allegations of Prime and RENISH going hand in hand and various unpleaded allegations. And the judge had rejected a submission that RENISH had intended to lull the bank into a false sense of security. So made all of those findings, there's no indication that those facts, and they are judicial findings of fact, were then taken into account when considering each of the 5th and 6th representations. That's the first point. The second point is, as we've just seen, there is no specific finding that there was an actionable representation. So at best, the judge has elided questions of actionable representation with questions of whether an inference of dishonesty was supportable. That is legally and rationally insupportable. Third, as the point I made in relation to paragraph 55 of the judgment, the judge did not make what was a necessary key factual finding to support an inference of dishonesty, because he did not make the finding about the mental state of the individual, Mr. MEHTA. That was a man, not a known fraudster, previously blameless, who had been involved on the judge's conclusions in an entirely legitimate commercial trading scheme involving the facility agreements, contracts Lanka, and 4 utilization requests. We've seen all he did was actually confirm there was no evidence to explain that position. Then fourth, as we've said, the only evidence the judge identifies as the basis for inferring dishonesty was the timing of payments out of Prime. But firstly, that point applied in the context of other advances on other utilization requests that were not the subject of fraudulent misrepresentation. And there was an explanation as to why payments were being made between Prime and RENISH. And in those circumstances, the conclusions were rationally insupportable. Fifth, the judge held that the full amount of the advances, which is 21 million that were made to Prime, were the consequence of fraud. But in fact, only $11 million were paid to RENISH. So of those payments, those what he called dissipations, only 11 million went to RENISH. And the judge made no findings as to alleged relationships between RENISH and third parties, such as Astron Global. So given he didn't make any findings, there was no rational basis for concluding RENISH could be liable for payments by Prime to unrelated third parties. There's no evidential basis, and so that's rationally insupportable. Now, those are the 5 points I make on ground 3. I'll just deal shortly with some of the bank's criticisms which are made in their skeleton. It said that the appeal doesn't meet the test. Well, I've just explained what the test was and that we are meeting the rationally insupportable head of that test. The bank has also said that the appellants can't rely on evidence filed by Prime. And now this is a chestnut we've been, this is something we've been around the houses on. But we say, in light of what the judge himself said at paragraph 24, that the judge should have been taken to material that went against the bank's case. That includes the points in the pleading from Prime and Mr. Sada and Mr. Drew. And we deal with all of that in the permission to appeal skeleton at page 69. That's A, tab 4, pages 51 to 55 for the court's note. But the bottom line is there was material which corroborated the appellant's position. It undermined the bank's case and it should have been taken into account. Third, it said that in his conclusion, the judge relied on the points in paragraph 35 of his judgment. But we've already talked about that. This is a reference to paragraph 54 in the judgment. The judge cross-referred in a general way. He did not identify specific points in support of his conclusion. And the only points that were relied upon from the judge's list was that there were payments made out from Prime shortly after the advances. And if the judge was really relying on specific particulars of evidence, he would have and should have relied and set it out in terms in paragraphs 54, 55, but he didn't. We say that a vague reference cannot satisfy the burden of identifying facts from which the only inference can be dishonest conduct. So, Your Honours, that's our position on ground 3.
Yes.
And I'm going to then move on to ground 4. Now, Your Honours, we deal with this in the recent skeleton at paragraphs 92 onwards, the permission to appeal skeleton at 72 onwards. This ground relates to the judge's failure to conduct the trial in line with the obligation of fair presentation. And that obligation follows from the obligation in the rules at 1.6 to run the trial justly. I take the principle from the CMOC case, which we had already looked at, which is I tab 32, so legal authorities tab 32, which is page 5011, 5011.
Yes.
And I'm looking at paragraph 14 in that judgment. And the court will be familiar with this principle. And it's based on a citation here from an earlier decision of Mr. Justice Cresswell in a case named Brass Petro. And what follows here is that, as Mr. Justice Cresswell had said, he had required the claimant to draw to the attention of the court points that factual or legal that might be to the benefit of the defendant. And in that case, that includes points that the defendant had taken before it decided to play no further part. So that would be arguments about the relationship between Prime and RENISH and why payments were being made after the advances here. Points which had never been taken but might have been taken if the defendant had defended proceedings. So that would include the correct legal tests and the fuller analysis that we have talked about. And they do that so that judges can then say in a case that has been conducted in that manner that they do not regard trial as merely an exercise of rubber stamping. Now, the judge did not raise this duty with counsel, and it's not reflected in the judgment or the transcript. There is no expression in the judgment or transcript that it is an obligation that the bank had understood it was to comply with. And the bank's submissions do not identify anywhere where they did expressly purport to comply with it. And Your Honours, this is not an obligation that is met by the judge himself testing the case. He did that. And we saw that the judge took the bank to task on the disparity between the pleaded case and the arguments made at trial and attempts to rely on evidence that had not been adduced. He rightly excluded arguments on that basis. But the fact that happened doesn't mean that the obligation of fair presentation, which is the presentation to the court, doesn't mean that that was complied with.
Well, I suppose the disparity between case as presented and case as pleaded, absent the defendant or the respondent, might fall within a general rubric of procedural fairness, quite apart from the requirements of pleading when you're dealing with fraud. This is a somewhat more diffuse principle, isn't it?
Well, Your Honour, it is, but I mean, the example you raise is an important one, because actually, what it would require if you are running a case that's not pleaded is to tell the judge, I'm running this, it's not pleaded, and this is what the other side would say. And if you are running a case on evidence that has not been adduced, then what it would require is you say, I'm saying this to you, but there's obviously these shortcomings in relation to the way this comes before you. I raise this because someone else would raise this. And equally, when you do rely on such evidence, if there's something in that evidence which actually undermines your case, and this is exactly what the judge picked out in his paragraph 24, you rely on it, you don't cherry pick. You say, against that might be said this. And you can say, but the answer is as follows. But the judge needs to require that to happen, and then it needs to be complied with. And this is why I say, if it was complied with, you'd see that all over the transcript. You would see actually something like what the judge has said in CMOG and what the judge has said in Petro about the assurances that they could feel about the process that had undergone, because they can say, I know all of this happened because we had this discussion. I required it to happen. They themselves put this forward in this way. We say, as you've got it, the points that we make in support, the law, the evidence, and none of these points were subsidiary, they're core to the approach. And it's a sensitivity that would apply in any context where it's a one-sided hearing. Here, the judge knew that, as he records in his judgment, the expectation was that Prime would play the main part and that their leading counsel would have been running the case. And that didn't happen. So then that means there's a... I'm sorry.
Can I just ask you, just looking through your submissions in relation to example, how does that make a difference to outcome in this particular case?
Well, so what we say is, if all of the proper points had been put forward to the court, then the judge would have dismissed the claim in its entirety, because he would have seen what the test required, the extra rigor, the extra points that had to be taken into account. He'd rejected the points that he'd rejected in any event, but he would not have been able to find, as he did on the 5th and 6th representations.
Mm-hmm.
And really, when you're judging
the judge was pretty robust in his denunciation of the bank in relation to the disparity between the pleaded case and case as presented, as he saw it.
He was, but that's something that he could pick out from looking at submission versus pleading.
Yeah.
He did what he could, but the rest of it was something he had to oversee in order to ensure a fair process. And he didn't do that. The consequence was these shortcomings, Your Honour. I accept that. The point that he went thus far isn't an answer to, but he should have done more. Perhaps the opposite question is more, imagine what he would have done had he been given the full picture. That's really what you're looking at. And that's really where we come down on this answer, Your Honour. So you've got the points that I make, and really that's the end of it. And so, Your Honour, with that, I conclude the submissions on ground 4 and the submissions on the appellant's appeal. Do you want to? I was going to just deal with some cross-appeal points now, and then I would rest. Do you want to take another short break, or shall we crack on? I don't know how the court wants to proceed.
It's too early for me to stop. If you don't mind, can you just continue?
Absolutely.
How long more do you are going to take? I'm not rushing you. I'm not rushing you. Okay. Our time is your time, so you don't worry about that.
Your Honour, I don't think I'll take much more than half an hour, if that.
Okay.
Because obviously.
Okay.
May I continue?
Yes, please.
I'm great.
Yes, please.
In overview, then, Your Honours, 2 points have been advanced plus additional reasons, and we say that they should all be rejected. Now, I'm not entirely sure what rulings have been made in relation to permission, but we say the short way through is that permission to appeal shouldn't be granted. But even if this court were to consider the appeal,
I think I should make clear that permission to appeal has been granted in relation to the cross appeal concerning the fourth ground, the fourth payment. On so the basis ground 1. That's right, and on the basis that it is limited to the alleged inconsistency between the judge's findings and reasoning in relation to 5 and 6 and his finding in relation to 4.
Yes.
And in relation to the costs, we've said, well, both parties can argue the PTA as though it's on the appeal, and we'll deal with it that way.
Your Honour, I don't think it's going to make much difference to the way I'm going to proceed, but I'm grateful for that clarification. And you've seen my submissions in the recent skeleton from paragraphs 100 onwards on the grounds, and I'm not going to be going particularly off-piste. In relation to the first ground, in relation to, is on the fourth advance, the second was on costs. Your Honour, there is also a separate argument as to grounds for upholding the judge's decision. We say that that is improper. It turns on a number of points that were not pleaded and not admissible. Can I move then to ground 1? We've already looked at the Volpe and Volpe point. I make 3 points. This court is only reviewing a decision made at first instance, so you're not rehearing the trial, and that's clear from RDC 44.110.
We're not within Ambrose Bierce's definition of an appeal, which is in law another throw of the dice.
No, quite right, Your Honour. It's out of the Devil's Dictionary.
Indeed.
Yes. No, quite right, Your Honour. And we're not in. There are certain circumstances in natural justice and so on that might be said to apply. They don't apply here. So we say that is an end to the nature of the inquiry. We do, for my second point, draw a distinction. I think this is the mirror or the cracked mirror analogy about the nature of our appeal, because we say the fundamental force of the bank's appeal is to ask the court to retry the position. And that's not what we are asking them to do, but it may be that the narrow scope for which permission is granted answers that point. But third and relatedly, the problem is that the bank prays in a significant additional evidence. And we said that that's improper, given that the judge made his findings on the evidence that was before him. Now, I want to talk about the additional reasons, which are put as a sort of final section, the last 20 pages of Mr. Reed's skeleton. I say that because it's relied on in support of their ground 1 appeal. And that's fundamentally improper, we say, for 3 reasons. Firstly, the review, not a rehearing. So you can't go into the undergrowth of the trial material. Secondly, even if you're considering upholding the ground on alternative grounds, you must rely only on evidence that's properly before the court below. And therefore you can't, we say, deal with inadmissible evidence or points that were not pleaded. Now, I'll deal with this in the skeletons. Can I talk about inadmissible evidence first? The rules forbid this without further order. So RDC 44.114 provides that unless it orders otherwise, the appeal court will not receive oral evidence or evidence which was not before the lower court. Now, I've already taken your honours to the judgment, and it's really paragraphs 37 to 39 that deal with these points. But the judge had rejected the unpleaded allegations in those sections. It also said that the material from Prime's witnesses was not admissible because there were no hearsay notices or applications to admit. The judge only accepted that such material might be relevant insofar as it contradicted the bank's case. So that should be the end to it. Your honours should not allow such material into account in this appeal. And I also then move on to the pleading point, because if your honour, essentially what the bank wants is for the court to proceed on the basis of an unfair and unequal footing. Because if you take into account an unpleaded case on dishonesty, that means you're considering arguments of which the appellants had no proper notice. If there was no notice in a pleading, it means the appellants have not had a fair opportunity to respond in pleadings and in evidence. Now, in its skeleton argument, the bank suggests that there's a requirement to plead concisely, which means that its argument is already there because it's contained in a general outline of the matters which it needed to address at trial, and so nothing more was required. We said that that's just wrong. The bank's pleading itself contained a lot of detail as to the basis for its claim for inferring dishonesty, and that's what the rules of pleading required. We looked at Keckman, Your Honours, you may recall it before the break, and Keckman cited Three Rivers, where you have to identify the facts on which you're relying in your pleading for an inference of fraud. But notwithstanding that, the judge excluded those 3 extra lines of argument. And we've seen that the judge also well understood the purpose of pleadings and notice, because that's all at paragraph 40. So those matters were inadmissible, and the court should reject the bank's attempts to lever in these points through a skeleton argument on appeal. And they're trying to do that because if the bank has attempted to resurrect its first unpleaded allegation regarding RENISH and Prime acting as a single entity, in its recent skeleton argument at paragraphs 80 to 81, it makes an allegation about the relationship and about Prime and RENISH operating hand in glove throughout the material time. But the judge excluded points like that, and it should be rejected here. At 74.3 in its skeleton, the bank attempted to resurrect a second unpleaded allegation about the timing of opening bank accounts. Well, that's been rejected. So that can't come into account. And there's also an attempt to resurrect the third unpleaded allegation about forged documents and a mismatch between payments and oil cargoes. Does that at paragraph 76 and 77. Again, that should be rejected. And Your Honour, we also saw a point that's baffled us at this side, saying, well, there were no requests for further information. Well, the bank is obliged to plead its case properly by referring to the factual particulars on which it relies for its case of dishonesty. A defendant is entitled to assume that the pleading against it contains all the facts on which are relied. The court would not expect a defendant to have to ask the claimant if there's anything else that they're wanting to rely on. So summing up then, Your Honours, if this court takes into account evidence that the judge below said was inadmissible, then it would be considering an appeal and reaching a conclusion on material the judge had refused to take into account. That would be wrong. And the same would apply if the court was somehow to entertain arguments that were not pleaded, because that would mean those were arguments that had not been notified. to the appellants. What the bank seems to ask for is that this court should rewrite the judgment below, but without the appellants having had a chance to respond in the proper way to these new arguments. And the only way that could possibly happen is with pleadings and evidence, and that's now far too gone. Now, can I move on to my third?
Sorry, is there any authority? Just looking back at the rules relating to respondents to 44.75, respondents' notice asking the appeal court to uphold the decision of the lower court for reasons different from or additional to those given by the lower court. Has there been any construction of the constraints or limits upon what such a notice? I mean, one might say, well, on one view, a narrow view of that would be reasons additional means a line of reasoning which is additional to that which was used by His Honour, without getting into the weeds of the evidence. But are you aware of any authority?
Your Honour, I don't have any to hand, but we can dig into that.
There might be some under the English rules, I don't know.
Yes. Yeah. Well, I wanted, it does relate to this third point which I want to make, Your Honour, because it really procedurally, the bank has got itself into a twist, because what it should have done if it wanted to re-argue its points on the fraud was to appeal the judge's order itself, because it should have asserted in its grounds that the judge erred because it should have found that there's a wider fraud and that the judge had wrongly disabled himself from considering claims that he wrongly said were unpleaded, and wrongly disabled himself from looking at evidence from prime. The court cannot use, we say, Rule 44.75 as a backdoor for that. Because actually, as I've said, the skeleton argument really wants to use these additional grounds to try and uphold ground one on facts and arguments that were not before the court. And even in paragraph 88, what's suggested is that if the judge, and I'm reading it, had considered all of the relevant evidence in the round, I don't know what in the round means, he would have been bound to conclude the entire course of events leading to the conclusion of the facility agreement form part of a single fraudulent scheme perpetrated by the applicants. Now, that's why I say they're trying to rehabilitate this entire case. And the court should see that for what it is. Because what it should have done, if it wanted to rely on an unpleaded case, but they thought the judge had got it wrong on, and should have let it in. And what it should have done, if it wanted to rely on other evidence the judge had refused to let in, was at that time say, sorry, judge, you reached the wrong conclusion. There's a much bigger fraud here. And you disabled yourself from realizing there's a much bigger fraud because you didn't let this unpleaded case in and you wrongly refused to look at this evidence. That's what should have happened at the right time. That's not what the bank's done. And so the bank has not taken that course, and it should not be permitted to resurrect an unpleaded and unevidenced case using additional reasons as some sort of Trojan horse. And the outcome, if the bank were to succeed on that, is that the court would find in the bank's favor on a case that hadn't been pleaded, and by reference to evidence that had not been adduced and had been excluded. That would be fundamentally unfair and improper, contrary to natural justice. So, Your Honour, that's the position on ground one and the additional reasons in toto. Can I deal shortly with ground two? Your Honour, Justice French essentially summarised the argument, having read it from the skeleton this morning. Can I just therefore make one point? And I've already said, the points about discretionary decision being within the ambit of what was reasonable. Second, the reason reflecting the outcome because they'd lost most of it and for the bank's conduct. Can I just look at the transcript, which is at G2472?
Page?
So page 2472, Your Honour.
2472, okay.
And which tab are we looking at, Mr. Pillay?
I think it's tab 1.
Okay.
Oh, no, tab 3. I'm so
Okay.
sorry. So this is at the end of the hearing. 2472, there's a discussion, I mean, I think it's begun the page before, but they're discussing the disposal from line 5 internally on there. You see Justice Glennie. And then he moves on at line 12 to costs. And costs, if you're successful, you want your costs. Mr. Reid says we'll be seeking our costs. I anticipate we'll be seeking on the indemnity basis, given the facts taking this case out of the norm. And then Lord Glennie says, you wanted to make that application now, or you wanted to leave that till after judgment. Would have been open at that point for the bank to say, let's see what you say, and then we'll come back to you. But what happens there is an application is made for costs. I'm happy to formally make that application now on the basis that this has been a complex fraud, it has required very costly and time-consuming investigation, and in those circumstances, we'd seek costs on the indemnity basis, and we would seek an order to that effect. Now, it was suggested that, well, all I was doing there was making an application for indemnity costs. Well, an application for costs on the indemnity basis is, firstly, an application for costs, and then, secondly, the indemnity basis aspect is as to the approach the court will take in relation to a discount or not. But it's plainly an application for costs expressly made, taking up an invitation at the time by the judge. So we don't.
At that stage, the parties maybe don't anticipate the possibility of a partial success, and that the bank succeeds on some things and doesn't succeed on others. And we all know that that enlivens a discretion to apportion or only award a portion of the costs and so forth. And that possibility wasn't contemplated or debated at the time. Ordinarily, you would expect that if the court were going to do that, it might invite submissions on costs where there's been a divided, partial success.
Your Honour, I appreciate that. I think what was contemplated here was a straight sets win. And as I said, it was one-way traffic. And what was suggested was that it would be, there should be no discount. And it's important because if you argue on the indemnity basis, you're essentially saying you assume everything in my favour, reasonable costs, of course, but otherwise you don't discount any further. So we say that on the face of it, we weren't there. So I'm giving you the transcript, Your Honours. We say that actually this isn't something that is properly the subject of an appeal because an application was made there and an election was made, frankly, because you know what the alternative is to wait till after judgment. The alternatives are expressly put there in that extract. Lord Glennie said, are you wanting to leave that until after judgment? So, Your Honour, those we say are the facts. The judge had, in the course of his judgment, expressed his concerns about various aspects of the bank's approach and its conduct. For example, the improper maintenance of the sham transaction allegations, the reliance on unpleaded allegations, the reliance on inadmissible evidence, and that was done on a cherry-picking basis. For all those reasons, we say that the court respectfully should permit the appellant's appeal and dismiss the bank's cross-appeal.
And substitute a different order for costs.
Your Honour, we would make submissions on that after the outcome.
Oh, is that right?
Your Honour, unless I can assist the court further, those are my submissions. I don't know how, I'm getting a little hoarse here, but I don't know how the court wants to proceed.
Yeah, I think for myself, not for now. I may come with more questions later after we have heard Mr. Reid, but for now I don't have anything else. Sir Justice Shamlan and Mr. Robert French?
Nothing from my side. Thank you.
That's fine, thanks.
Okay. Yeah, Mr. Reid, you want to say something?
My Lord, can I just propose that we break for 10 minutes just so that we can gather our thoughts in the light of what we've heard from Mr. Pillai?
Do you want to continue? You want to continue today? I thought, according to program, you're supposed to start tomorrow. I mean, fine with me, But
my Lord, I'm entirely in your hands as to what your lordship's.
According to the program, you're supposed to start tomorrow.
I'm very happy to do that.
I think then you will. How many hours do you expect to take tomorrow? Why don't we do it tomorrow? I mean, I'm prepared my mind to do it tomorrow, although it's still just 6:30
You can truly gather your thoughts, Mr. Reid.
In that case,
If I were counsel, I would want an overnight to think it over.
Okay. In that case, so be it. Well, just in terms of overnight reading, the learned friend made, I think, one fleeting reference to the judgment of Justice Blenny on the PTA, the permission to appeal application, which your lordship has immediately behind the judgment. There is authority in the CPR that's effectively that the reason the first application for permission appeal goes to the judge himself is that he or she has an opportunity to clarify and explain what they said in the judgment. And there is Court of Appeal authority in this jurisdiction that the Court of Appeal, the appellate court, can consider the amplifications, clarifications, etc., in the PTA judgments that I'll refer to. So, although my learning friend hasn't referred to it, it is in my submission a very helpful document. If the court were minded to read it overnight, it does provide the answers to some of the questions the court has raised, Mr. Pillai has set up. Thank you very much. Thank you very much. Thank you very much, Did. May your voice, your sound system, do you mind, Mr. Reid, putting the microphone closer to you? Because I get this, I don't know about Mr. Justice Shamlan and Mr. Justice Roberts, but I get that hollow sound coming from you, Mr. Reid. Whereas Mr. Pillai, I could hear a very solid sound coming. Is it because your speaker is away from you, or is it you? We have a fancy AV system, which means the microphone is somewhere up there. But I will try and address the problem. Maybe you want the speaker next to your mouse rather than this distance. We will look at that overnight. Please, because otherwise I constrain to hear what you're trying to say. So tomorrow, 8 o'clock. Do you want to start at 9 your time? My lord, I've got a fair amount to say. So in fairness to my clients, okay. I'd be happy to make an 8 a.m. start. Okay, 8 a.m. tomorrow, your time. Dubai is what time? Shamlan? 11, Dubai 11. 10. Dubai will be 11 a.m. Currently, there's a 3-hour time difference. Oh, I see. And so 8-11, and we are 3 p.m. Robert. Yes, we are. Yeah, 3 p.m. tomorrow. Okay, I'm going to put on my paper to 3 p.m. tomorrow. Court is adjourned to 3 p.m. tomorrow, and you calculate your own time. 8 a.m. Sorry, 8 a.m. London, and 11 a.m. Dubai. Okay, we'll see you tomorrow then. Thank you very much. Thank you. Judges, do you want to have our discussion ourselves on our own today or tomorrow, or immediately now? Or do we need?
We can have it tomorrow, 30 minutes before the hearing, as usual.
Yeah. Okay, 2:30. Okay, then. Thank you very much.
All right.
Thanks a lot.
Thank you. All the best.
Bye-bye.
Thank you. Bye-bye.